slavery gave rise to the struggle for fair wages. The struggle for political representation strengthened the fight for workplace justice. The recognition of trade unions empowered workers to organize, to bargain collectively, to advocate for better working standards, and to achieve them. And universal adult suffrage ensured that every Barbadian, the voices of ordinary working class people who had previously been excluded from the electoral and democratic process, could shape the laws of this country. It is therefore no coincidence that the legislation to protect workers would also come at that same period in which national transformation was achieved. It reflected an understanding that political freedom, which is essential, is incomplete without economic and social justice. A worker who cannot depend on receiving the wages that they have honestly earned cannot truly enjoy the full benefits of freedom. 75 years later, in this chamber, we have the opportunity and the responsibility to continue to strengthen those protections for a new generation of Barbadian workers. This bill, to me, therefore, Mr. President, is about much more than simply wages. It is about continuing unfinished work of people who came before us, who sowed seeds, understanding that dignity of labor must not only be protected in principle, but also in law. This bill asks us very profoundly, what does a worker's wage mean to them? Do we simply consider it a financial transaction between an employer and an employee? Or is it simply an amount reflected on a pay slip or deposited in a bank account? I want to submit that it has to be much more than that. Because before I ever understood labor legislation, industrial relations, or public policy, through my education at the University of the West Indies and now as a trade unionist at the Barbados Workers Union, I had to understand it through my parents. My mother, as I've said before in this chamber, was a domestic worker, and my father, a mason. And so they taught me long before, and like many Barbadians, I learned what work and hard work actually meant. I watched my father often leave home at 6 o'clock to get to the job site. I watched my mother do the same to return home, exceptionally tired, but somehow still find the strength to care for a family of 3, need I say, very hard-eared children. I watched them make sacrifices that as a child I could not appreciate, but as a young woman, I definitely understand and weigh in terms of creating a family. And wages weren't just money for us. That was how they kept a roof over our heads. That is how they put food on our table. It is how they bought our school uniforms and textbooks, paid for bus fare and all the other expenses. And so every dollar earned in a household for a working class family represents hard work and physical exhaustion, but there's often no excess. And so those wages are not a luxury. They are a necessity for them to survive. And I want to note that COVID showed us exactly how easy it is for a family that appears to be thriving in our idea of that word to find themselves on the breadline and unable to purchase simple necessities. And so protection of wages is one that is recognized under concepts such as decent work of the International Labour Organizations, as said before. And it is built on 4 pillars. It is built on employment, rights at work, social protection, and social dialogue. And so we cannot speak about decent work if persons cannot depend on the wages that they have earned. A person may have employment, but if they are not paid on time, if unlawful deductions are made from their wages, if they have no effective means of redress, when those rights are violated, then dignity in work is compromised and ultimately denied. How we protect wages says something about the kind of society that we aspire to be. If we believe, as we say, that labor is the engine of our economy, then we have to believe and indeed ensure that those who provide that labor have certainty and our protection. The timely payment of wages is not an act of generosity by any employer. It is not a favor being done. It is a legal obligation, a moral responsibility, and a fundamental component of industrial justice. Mr. President, Section 3, subsection 4 reflects that principle by providing that a contract of employment shall provide for the entire amount of wages for a pay period to be paid directly to the employee in respect of all work done during that period. Because if you perform your duties honestly and faithfully, you should receive every single dollar that you have earned. However, what concerns me is that too many workers in Barbados are still falling through the cracks because they lack contracts. The Employment Rights Act also contemplates contracts of employment and establishes rights and obligations arising from the employment relationship. Yet, despite our legislative framework, there remain employers who continue to engage workers without providing clear written terms and conditions. And so too many workers begin employment with nothing more than a verbal promise. They are told when to report to work, what they will be paid, and perhaps when they might be paid. But there is nothing that actually follows what is set out, both in this legislation and also in the Employment Rights Act. And so when disputes arise, those workers are immediately placed at a disadvantage. Without the written terms, any disagreement over anything like wages, hours of work, overtime, leave, periods, deductions become very difficult to resolve because it really is a he say, she say conversation. And so workers are trying to prove what is agreed, and that imbalance undermines dignity for the persons that this legislation seeks to protect. I also believe that we have to be honest here, and I see it oftentimes as a trade unionist, that remains a culture among some employers who believe that the law is optional. Matter of fact, yesterday I had a call where someone said to me that they were told that you have your law, but in here we have mine. And so what does that mean? That means that you believe that the Employment Rights Act is merely a guide, or that the Protection of Wages Act is merely a suggestion rather than binding legislation that employers are obligated to follow. I wish to inform all those within the sound of my voice that there is no code, there is no policy that an employer can offer you that supersedes or is higher than the law of Barbados. They are bound to it. And so employers are not a law unto themselves, in the same way that we as employees must abide by the policies that they provide us with for work that align with the laws of Barbados. And so they establish their own workplace rules, they disregard statutory obligations, and they expect workers to accept whatever conditions they offer to them. Mr. President, that cannot be the Barbados that we aspire to or that we accept. And so the laws represent the minimum standards below which no worker in Barbados should be required to accept. And that minimum standard does not mean that you cannot surpass expectations. It says that this is where we draw the line on what is acceptable and what is not. And so if we are serious about decent work, and I'm going to come to this later, we have to be serious about ensuring compliance with those standards, because no worker should have to choose between earning a living and being able to assert their legal rights. I also welcome Section 3, subsection 11, which provides that where wages are paid in cash, no more than $10 may be paid in coins. And to be quite honest, I was a little baffled by this, but then I heard the reports of how persons are being paid in excess. And sometimes when we give persons even a little change, and it has in our mind too many coins, we tend to apologize. So there is something quite nefarious to me. There is something quite nefarious to me about paying somebody over $100 in coins. You are seeking to actually purposefully present yourself as a menace to this person. But it also shows a level of disrespect to expect anybody to put that amount of money in their bag. Where is the dignity in that? And that also speaks to common human decency. And so it also requires that where wages are paid by a method other than cash, including directly into a financial institution, that the employee must be allowed a reasonable period during the usual business hours of that financial institution to convert those wages into cash where necessary. And this is particularly important because it has always struck me that we have what you might consider a uniformity in work hours. When the banks are open, workers are usually at work. When the banks are closed, workers are usually, some of them are at home and they can't go to the bank. And so it means that if employers do not facilitate this, that persons may be left without access to funds, particularly persons who do not utilize ATMs. And we also have to appreciate that a digital divide when it comes to accessing certain services still exists. And so there are persons that prefer to go to the ATM to do everything from depositing a check to withdrawing money. And then there are others who prefer or have to, based on their limitations or their desire as they are entitled to, go to the teller in order to withdraw their funds. And I want to address another issue, which I believe a clear message must be sent on the protection of deductions from wages. Because when you receive a pay slip and you see deductions for national insurance contributions, pension contributions, union dues, or any other deductions, workers accept those deductions because they understand the purpose that they serve and they have agreed to them. The protection in terms of illness, maternity, unemployment, or retirement, the right to be able to access representation, pensions to secure their futures, and other deductions are not, it's not the employer's money. It is not for you to hold on to. It should be deposited. And so once these sums are deducted, they should be held for a specific purpose, and they legally belong to the institutions in that they are owed. And too often we hear stories of persons who find out after the fact that no money has been paid on their behalf into these institutions, and therefore they cannot access the benefits that they are rightfully entitled to. And this is not to say that the vast majority of employers are doing this, but it is to say that the one employer that might be doing it, or the two, is one or two, way too many, because the worker is on the other end suffering, sometimes unable to get a timely redress, and that affects their quality of life. And that is a profound injustice that has to stop. And so protecting wages means more than ensuring that workers receive paychecks, but making sure that every lawful deduction goes to the place that it belongs. I want to speak about the fact that this bill also focuses on access to justice. Far too many workers, the issue is not knowing that they have been wronged. It is knowing where to go, who to turn to, and whether the system will work for them. The point of having systems or places for redress is so that people can access justice. A right that cannot be enforced is not really much of a right at all. And this is why I welcome the provisions contained in this bill, which strengthen the role of the Chief Labour Officer and provide a clearer pathway for complaints to be brought before the Employment Rights Tribunal. The bill recognizes that employees may make complaints, but it also recognizes the role of trade unions and representative organizations in bringing complaints on behalf of workers and groups of workers experiencing the same challenges. And it is important because not every worker is in a position to challenge an employer on their own. But we also still have employers who still seek to undermine the rights of Barbadians as provided in the Trade Union Act to join unions and to seek representation. We have employers that use every single tactic in the book not to engage with the established or recognized trade union, as well as to negotiate in bad faith. And if we know that these things are happening, it is not sufficient to know. We need to do more to ensure that workers feel comfortable without fear of favor of going to their trade union representative to be supported. And many workers are afraid. They're afraid of victimization because if I go to the trade union, I may wake up tomorrow and realize that I don't have a job. They fear being labeled as difficult. They fear that if they stand up for their rights today, they may find themselves on the breadline tomorrow, and that fear is real. And it is the reason that trade unions exist. It is also the reason that they remain as relevant today as they were decades ago. We are not merely here to negotiate wages and conditions of employment, but to ensure that workers have a collective voice when they are unable to speak alone. A lot of workplace disputes are not individual disputes, and sometimes an entire group of employees is affected by the same unlawful practice. Sometimes workplaces develop cultures where labor laws are routinely ignored. In those circumstances, workers, and this bill ensures that workers will not be forced to fight the same battle individually, but that they are able to rely on their representative organization to advocate on their behalf. I also welcome the penalties contained within this legislation. A couple of years ago, I admitted to my mother that when I was young, I would often calculate the amount of trouble I would get in. And I would calculate the amount of pleasure that trouble might give me, or the risk. And then I would decide whether or not I would do it, or whether I would leave it alone because I didn't want the licks or I didn't want the punishment. Maybe I had something going on.
Cost-benefit analysis.
Exactly. Cost-benefit analysis. And I want to say that employers do the same thing. They calculate that it is cheaper to breach the law than to comply with it, or that the justice that the employee can receive will take much longer and be way more inconvenient than actually doing what they're supposed to do, and this sets a dangerous precedent. The bill makes it clear that employers who unlawfully fail to pay wages, make unlawful deductions that otherwise contravene the Act, commit offenses, face significant fines, imprisonment, and orders requiring payment of the wages owed. We are not trying to punish employers, good employers, because there are many. What we are trying to do is to create accountability and to make sure that persons understand that there is weight and that there is value to labor, and that it is essential that we respect people's rights to their wages. Good employers deserve a level playing field. because bad behavior tends to spread. One bad apple ruins the bunch, and if I realize that you could get away with it, why would I not test my luck as well? Some of us also understand that cat luck and dog luck. But also, there are some people who simply understand that it is a wise financial decision to treat people well. Employees are often more willing to engage, they're happier, they're more productive when they are treated well. As I reflected on the bill, I found myself going back to a very simple idea that a lot of these laws, as I said, they're not just about compliance. It really is about human decency. It is about recognizing workers as not machines or robots, but that they are people, that they're mothers and fathers, young people trying to build futures, older workers trying to retire with dignity, caregivers who are balancing demands of work with caring for aging parents and loved ones. And so when we speak to this bill, we are speaking about protecting people. As I close, Mr. President, there's a question that popped up, and I often wonder it sometimes at work while I'm engaging with workers. And I ask myself, how many employers would be willing to accept the very conditions that they expect their employees to endure? Would they accept working without a written contract? Would they accept not knowing whether they would be paid on time? Would they accept having deductions taken from their wages only to discover later, years later, that those contributions have never been paid? Would they accept working in an environment where they're constantly disrespected, undervalued, or feel disposable? If the answer is no, then the question is, why do we expect that anyone else would? Respect in a workplace should not be a luxury. It is a minimum standard. Too often we have been hearing employers talking about not being able to retain staff and having high turnover. We hear discussions about labor shortages, declining productivity, and the migration of skilled workers. We spend a lot of hours trying to analyze why people are leaving jobs. But how do we actually treat people when they come to our workplaces? Because no amount of recruitment can compensate for a workplace that people are desperate to leave. People don't leave organizations because of the work. Oftentimes they leave because how they are being treated. People who feel respected are more engaged. People who feel valued are much more committed. The protection of wages, Mr. President, is part of a much larger conversation that Barbados must continue to have about the future of work. We must continue to speak about mental health and psychological safety in the workplace. We have to continue to speak about burnout and excessive loads, flexi hours, and remote work. We have to continue to examine toxic workplace cultures that demand more and more from workers while giving less and less in return. Mr. President, we want to be a nation that attracts talent, retains talent, and builds a productive workforce. Then we must build workplaces where people are not simply respected because the law requires it, but because it is genuinely the right thing to do. If that is the culture that we aspire to create, I want to say that this bill advances that vision, but we still have work to do. And with those few words, I'm obliged.
Thank you very much, Senator Trimby. Senator Goodrich.
Thank you, Mr. President. Good afternoon to everyone who's here in the Senate. I want to say a special good evening to all of our distinguished guests. Mr. President, I rise to discuss this protection of wages bill of 2026. Mr. President, I know that when I looked at the bill have a lot of useful provisions that could be beneficial to any employee. And I also look at the existing law, which is the Protection of Wages Act, Chapter 351. And if you look at that piece of legislation and you really look at it and see the penalties in that old piece of law, then you will recognize we are in modern times. So the existence of that bill to be applied to our personal challenges today, you will have problems. So this bill that we're discussing now is like a wholesale replacement to that. And I would say that is necessary. I would say that yes, I am appreciative of certain clauses that are in the bill. But of course, as opposition senator, I have some concerns with it. But I will look to the positive first, sir, because I know that every employee wants to know that their wages are protected. They want to know when an employer deducts their salary and the reason for it. And they will appreciate that today you can have notice in writing for that. And the reason why the money will be deducted from your salary. And that employer has to also let you know the procedure to appeal. So all of these things are essential. And as I said, when you look at the old bill, the existing one, that's the one that dates back all to 1951, and you recognize the penalties in there if an employer illegally deducts your wages. My God, the penalty was only, what, $48 for the first offense. We look at Section 15 of that act, and $96 for a second offense. So you can see, what's $46? What's $96? That's an insult to an aggrieved person, Mr. President. So, Mr. President, firstly, I want to look at this section. This section 13(1)(b), it prevents an employer from deducting wages from employees simply because they have done bad or negligent work. So we can't always say that when an employee is doing bad work, that it is the fault alone of the employee, because it could have to do with supervision, and the reason for that bad work, bad workmanship, could have to do with ineffective management. It could have to do with inadequate training. So an employer now cannot use that as a tool, against the employee to shift that responsibility now for you to do your best. No, because you don't want to have your wages deducted. And no one wants to have that. You don't want to know that you may not be at work and doing your best in an office and then your wages are deducted. So when I say that the bill has useful provisions, I speak to that one. I speak to that provision because I recognize, sir, that this provision, it benefits not only the employee, but it also benefits the employer. And we're looking at both, because I'm not going to only look at this bill and only look to see, okay, well, let me see how this bill is going to benefit just the employee. I want to know how it's going to also benefit the employer in this country. So it's a genuine win-win, sir, for both parties, both the employer, who would do better management of the employee, and also the employee. They should come to work proud, knowing that, look, my salary will not be deducted because of bad or negligent work, but I am going to put my best foot forward in the workplace, nonetheless, because I appreciate the fact that I have a job. So, sir, however, notwithstanding those many positives of the bill, I want to state that I do have concerns with this bill and certain provisions of the bill, sir. And our role as the national body of second sober thought in this country is to ensure that we highlight the provisions that will lead to unintended consequences, and also to make recommendations where necessary. And the necessary recommendations that I will highlight, I know would be a benefit to a country such as Barbados, a beautiful country like Barbados, that we want to ensure that every bill that is passed don't have unintended consequences on the people. So concern number one, sir, when you look at section 3, 11, subparagraph B, it requires an employer paying wages by a method other than cash to allow an employee a reasonable period to convert the payment into cash during the normal business hours of the financial institution. So that's happening right there in normal business hours, where that employer paying those wages by a method other than cash to allow an employee a reasonable period. But I'm going to say what is a reasonable period, because what is reasonable period is a reasonable period to Senator Goodrich may not be a reasonable period as the same to Senator Walters or any other senator here. So when I leave work, and this applies to me, and I go now to the bank, a lucky day, a lucky Friday, you may find 2 tellers and that may take an hour. Leave work in the rush hour. That rush hour, I'm telling you, it would take hours stuck in traffic. Everybody's not rich. So even if you have to walk or you have to catch the bus, what is a reasonable period? My recommendation is that that must be clear, because when that employee whose wages are deposited directly into that bank account then has to go to the bank, sir, and we do not help the workplace by stating what is a reasonable period, then chaos could emerge, problems could develop, and that cannot be the policy objective. This provision may have been made a perfect sense decades ago, I believe, where wages were commonly paid by check and employees had little alternative but to visit the bank. And we know at the old law, sir, it wasn't appreciative of even acknowledging deposit accounts and wire transfers. But yes, the bill does have it here. But today, sir, we live in a time where you have ATMs, bank cards, and you can go there. So I was wondering when I read that, like where were we going with saying, okay, the employee can have that, a reasonable period to go. And I think of myself, as a prudent employee, and wondering if everybody's prudent, because I know not. I know that everyone does not think the same. So when you say reasonable period, please, sir, I do believe that it should be defined. Otherwise, we are creating an undefined entitlement that may unnecessarily reduce workplace productivity. And every employer in this country wants to know that their workforce is a productive one. Businesses are created to make profit, and we cannot in any way encourage anything that will lack profitability for any company in this country, sir. And that was my first concern. My second concern, it relates to Section 14, which governs the recovery of overpaid wages. We know that that happens. Man is not perfect. So basically, you will have a payroll officer who will be dealing with the employees' wages, and that payroll officer, an imperfect man or woman, could make a mistake. So this section swings a bit too far in the opposite direction in my view, and I will tell you why. Because consider a simple payroll error, sir. A payroll officer intends to pay an employee $1,000, but accidentally enters, mistakes basically the cents from the dollars, and then enters 100,000. You know me. If they give me, sir, I'd be happy. But it ain't mine. Of course, if I wake up and I get that 100,000 and I see my account, I know I work for that, but I see it in my account. As mistakes happen, and God knows the bill is still silent on the time limit for recovery. It doesn't have it there, the time limit for recovery, so we don't know when they will actually discover that this overpayment actually happened? I'm not certain because the bill is silent on that. So we don't know when on earth that payroll officer might discover it because God knows. You might not always find an honest employee. Myself, I will come to work and say, I recognize that I got paid $99,000, a bit over, huh? But not everybody will do that, sir. So we have to be careful because when the employee wake up and find that 99,000 sitting in his account, hallelujah to him. Under Section 14, the employer may recover the overpayment only from future wages, and subsection 3 limits the recovery to 1/3 of each pay period. Now let that sink in for a moment. Because if that employee earns the $1,000 per week, that means the employer may recover only $333.33 per week, okay? All right, but you owe all of that money, $100,000. You was only supposed to actually receive $1,000, but you get all of that money. It would therefore take, sir, approximately 300 weekly deductions, almost 6 years. So imagine the employer. That takes 300 weekly deductions, almost 6 years to recover the money, assuming the employee remains employed, because the person could get dismissed or the person could resign also. So they have to wait then, based on this law. It's going to take them a long period to receive that money. So I believe that the law should make provision for situations such as that. Because during that time, sir, the employer receives no interest. So I have to ask the Senate today, is that fair when an employer pays you that $100,000 and receives no interest? So the employee, are basically getting an interest-free loan. That is exactly what it is. When you look at the circumstances that could be created based on those provisions, you recognize that individual that were overpaid actually has an interest-free loan. Sir, I don't believe that it is fair. The result is that an employee who received money by mistake effectively enjoys an interest-free loan at the expense of the employer. So there the employer now had to be grinding and saying, look, this employee got all of this extra money out of me. All of those create bad employer and employee relationships, sir. So we as Parliament have to ensure that these sort of scenarios are covered by the legislation. A more balanced approach will permit larger recoveries where the employee agrees or allow the tribunal to approve a reasonable repayment arrangement in exceptional circumstances involving substantial overpayments. We should not legislate unfairness in either direction, sir. Sir, another concern that I have, there's a section here that provides that the employer or his agent who makes an unlawful deduction from wages is liable upon summary conviction to a fine of $30,000, imprisonment for 3 years, or both. I assume this section is intended to refer to the illegal deductions, of course, and we, of course, will seek clarification of that in the committee stage. But the bill does not define an agent. So me reading it, of course, doing my due diligence, I'm wondering, but who really is the agent? I'm not sure because the bill doesn't specify. So suppose a payroll clerk receives an instruction from the top. Say that instruction comes from a human resource manager to deduct money from the employee's wages. And they follow that instruction because you have to respect the order. And you know what people know what it is to respect the order. You respect the order in the workplace. So if you receive an instruction, it is obvious that you are going to follow that instruction. So you are going to follow the instruction of the person who is above you. So when it says an employer or his agent, it comes to mind, brought that to mind when I'm thinking about the human resource manager giving some instruction or whoever is above the so-called agent because it's not defined. But if the deduction later proves unlawful, sir, should the payroll clerk now face a criminal conviction? That's the question I'm going to ask today because there's a possibility of imprisonment there. And to me, in my view, it seems unjust. So unless an employee's duty would specifically include interpreting employment legislation and determining whether the manager's instruction really comply with the law, the liability should rest with those making the decision, sir, not just merely those carrying it out. Because then society will look at it and they may agree with me and say, well, it looks a little bit unjust and unfair because you just followed an instruction. And if you followed an instruction, then why am I being taken down with you, with your bad instruction? So the persons...
Yes, Senator Allen, what do you raise?
Yes, on a point of order. And I hate doing it, but the law, the law takes care of many of these issues. Everything doesn't need to be stated within a piece of legislation. There's a definition at law as to who constitutes an agent. There's also a requirement of something called mens rea in terms of actions, such that individual who's an agent of a higher, who has no mens rea in terms of their act, won't be held to be liable. So I don't know that these are concerns as put forward by the honourable member that may confuse the populace out there. These are things that are taken care of by law.
Thank you very much for that legal expansion. Please continue, Senator Goodrich.
Thank you so much, sir. I will respond by stating that if the honourable senator is correct, when problems occur in this country, then people will remember the words that he said, because if he's saying that the word agent is clear, well, they can call him when problems emerge. I will move forward. So, sir, pro bono. Sir, my next concern, which appears, you see, this is a sensitive one, because I wouldn't be angry if the government defended this. I wouldn't be mad at you, because I wouldn't want to think that the government would encourage any kind of unequal treatment. So everything rests on interpretation of the legislation, you see? And that is why we have to go before judges many times for the judge to make the final judgment based on the arguments of the legal counsels who come to the court. Because when I look at this bill, I'm wondering when it comes to the penalties that apply, sir, to the private sector and to the public sector, I'm wondering, is there any unequal treatment there? Because when I look at the bill, I went to section 28, I look at section 1 there, and 2, and sections 2 to 19 expressly bind the state. That's my interpretation of the law. But the offense provisions, which are the provisions that will come in section 25, right? Those don't seem to be applying to the state. So the result appears to be that private employers may be prosecuted, fined, and imprisoned, while comparable breaches by the state are dealt with through internal grievance procedures. Now, I know the leader of government business, she was speaking earlier, and she said that this bill binds the state, but I don't know if she was saying binds the state in its entirety, because those provisions there are supposed to bind the state, which is sections 2 to 19. So if that interpretation is correct, sir, then we are really creating two systems of accountability, which is one for private employees and then one for the government. So that is difficult to justify, because then they have to ask, then where are we doing that? Where are we doing that in the country? I don't quite understand it, and I will seek clarity, because if Parliament believes these offences are sufficiently serious to justify criminal sanctions for the employers, then those sanctions should apply equally, because sanctions here affect the owners of restaurants, affect the owners of construction companies, affect the owners of any place that employs employees. So think about it. What happens then? Are we saying now that it does not affect the public sector? So if they are not appropriate, sir, then to apply to the ministers or permanent secretaries or public officials acting as employers, then perhaps they are not appropriate for the employees of the private sector. So equal justice under the law demands equal treatment, sir. So either we fine all or we fine none. Either we imprison all or we imprison none. Don't imprison nobody, don't fine nobody. But it cannot be a case where we are only doing it for the private sector. It is not right. Sir, I wish to address the penalties themselves. This new bill introduces imprisonment for a number of regulatory breaches. This reflects a worrying trend for me, because we observe it across some of the bills before the Senate. Increasingly, nonviolent regulatory offenses are being made punishable by imprisonment. Why? They are not offenses, in my view, involving violence. They are not offenses, in my view, that are a threat to the public safety. Right, sir? Many of them may arise from misunderstanding, administrative error, or inadvertence. And this happens often. As I said before, people are not perfect. So when people's imperfection gets in the way, there is the existence of a possibility that they may be in prison. Sir, as I said, many of these things arise from misunderstanding, and I don't think that the public would tell me that I'm wrong there, because man makes error, and it can happen quite often. So certainly, sir, deliberate exploitation of employees should attract meaningful penalties. But must every breach expose an employer or potentially an employee acting as an agent to imprisonment? Is this the only way we can think of dealing with them? We should criminalize violent conduct. We should impose substantial fines where appropriate for regulatory offenses. But we should be very slow to imprison citizens for nonviolent breaches of increasingly complex legislation, sir. So before long, ordinary Barbadians may find themselves exposed to criminal records, and we don't want that, sir. We don't want to just be imprisoning people for making mere errors. And that should concern, sir, every member of the Senate. We recommend removing the custodial penalties from this bill and relying instead on meaningful financial penalties together with the existing civil enforcement mechanism, sir. And I don't think that that is a bad idea at all. So the bill contains many worthwhile reforms, and we acknowledge them, sir. I acknowledge them, and I will even spend some time highlighting them, because I listened to the leader of government business, as she mentioned. So Section 14 will give the employer a lawful route to recover a genuine payroll overpayment. But as I said, I had my concerns with that based on the 1/3. Section 17, it makes unpaid wages a preferred claim if an employer becomes insolvent. Because these are things that happen. An employer can become insolvent And when they become insolvent, we still want to ensure that we are in line with the international best practices. So we always have to remember that little Barbados not just here on a rock on its own. We have to think internationally, and we have to wonder what are the best practices that we must align with. And that is one. When a company becomes insolvent, then the bill provides, yes, the protection for it. And sir, again, with Section 20, this is one section that is a useful provision because, as it is said, this bill instead channels wage complaints. So if you have a complaint, you can be heard now. Before, under that old piece of act, that old legislation dating back to 1951, all you can do is go to court. You didn't have this opportunity to go before no employment tribunal. But now you have that opportunity where you can go before an employment tribunal, sir. So all of that is essential for us today. So, sir, the recommendations that I've made, I pray that the Honourable Senate would take them into consideration, and that is my respectful submission to you. And, sir, as per usual, it is always an honor and a pleasure of mine to keep the bees in check.
Thank you very much, Senator Goodrich. Of the speakers, Senator Nels.
Good afternoon, Mr. President. Good afternoon, Senate. I'm going to go way out in left field on this one because I think all the sentiments pertaining to the bill have already been expressed very well by all the speakers before. And I'm going to start, for fear of not being quoted or misquoted on brass tacks tomorrow, I'm going to start by saying that I think we have all realized now that we are all slaves to the situation. This is a situation that for 75 years have been in the making. The situation, as we may want to define it, sir, relates to a commonality that precedes us and will go many years into the future. This act, if you flip the act around, albeit that the act is addressing the particular situation as we understand it to be, workers being unfair in some regards, unscrupulous employers doing what they choose to have done over the years. This act is seeking to stop that type of behavior. But what this act is doing now, and as I say, the slave to the situation, because this act is forcing a conversation, a financial conversation that has been swept under the rugs in this country for many, many years. And the financial concept is cash flow. This bill, when you strip out all the bad actors out of the bill, all the people who do the wrong out of the bill, the act comes down to a simple mechanical calculation when it comes to being an employer, and that is whether or not you are able to make that bid that you have put into your contract with an employee a payday. And if we look at the situation in the act, and the only thing I found in the act that was very interesting is that there's a gap in the act. It made no defense anywhere in the bill for an employer who cannot pay on time through no fault of his own. It's merciless. It says once you've established that payday, then that's it. And if you don't deliver the pay, then this is the consequence that you will get for the action. The conversation then moves from that then into the one of finance. Whether or not this country is caught in a dilemma whereby businesses cannot meet paydays because of financial constraints. Are we asking all the businesses in Barbados, small and medium-sized ones, to spend an enormous amount of time every day, every week, calculating the next payday, calculating the next payday? There are significant institutions in this country, sir, that habitually sends out notices saying pay will be delayed. Correct. Pay will be delayed. pay with it. What's going to happen when this bill comes into, when the act comes into force? I think many of my colleagues here have all spoken very well, but they're not in the private sector to the consequences that we understand the private sector to be. I'm in the private sector, so I can speak to a lot of these situations. There are significant institutions, government or otherwise, that cannot meet their payday. What is going to happen when this bill comes into effect? The person at the end of the day who gets squeezed is always the employee. So as an employer, I'm to guarantee your wages, but the employer at some point is an employee. The employer is an employee of the situation. If you take, for example, you take a contract, you're in construction, you get a contract with government or otherwise to build a property. You may ask for some money, mobilization fees. Those are paid. Then crap or smoke your pipe on every other drawdown. The QS comes in, this body comes in, that the fourth comes into the equation. And you find yourself then living at the mercy of the bank. If you're so fortunate to have overdraft, you're living at the mercy of the bank. The bill does not speak to those situations, and I would love it to have addressed those situations. The dilemma is not always about people being unscrupulous or wanting to do wrong. It's about a situation that this country finds itself in. I'm sure that if you're on the government side, the financial rule says that you should not enter into a contract whereby you willingly know that you have no funds to support that contract. It is there, but yet, as a practice, we do it. We engage people to perform work knowing that we can't. What happens in the other scenario? So you have a school, and you have teachers out for whatever reason, and you bring on temporary staff, and then this temporary staff can't be paid for months. As I heard this morning, maybe it's the fault of the Secretary-Treasurer. But for the most part, it comes down to the estimates, which says there's no money in the estimates to pay the additional person. So let's wait for a supplementary, let's wait for X, Y, or Z down the road. It forces us into this conversation of cash flow. Everybody owes everybody in this country. The private sector owes the government millions of dollars, whether it is VAT or otherwise, and likewise the government of the day owes the private sector millions of dollars, VAT or otherwise, in terms of repayment. I understand what we're trying to do in terms of protecting the worker, but it has to be a slightly different conversation when it comes to dealing with the realities. And the bill needs to have a provision somewhere in there that speaks to a scenario whereby it is no fault of the employer if he cannot meet that payday. And the bill doesn't distinguish between whether you are a shopkeeper in Oistins and you employ 2 persons, or you're the mite of, I don't know, the biggest financial institution in this country with thousands of workers. It simply says this. And if you don't, this is what happens. So we fundamentally have to address these issues. Yeah. How are we going to speak to what happens next? Once we speak to what happens next. I was telling some colleagues at around lunchtime that a friend of mine contacted me, and he asked me for his advice. With this bill, he didn't understand it, but he heard about it. He employs about 10 people. He said, you know what I'm going to do now, Z? I'm going to sever 3, because I could guarantee 7. The other 3, the other 3 was good to go, but I can't afford, because if I calculate the severance for the 3 persons, it is less than $20,000 if I can't pay them, for whatever reason. Do we want to force those kind of conversations into the economic space of Barbados. It is Barbadians who do this to Barbadians, you know. It is not people from Mars or other places. Many companies have lawyers, and they will call their lawyers, and they will ask for an interpretation. And their lawyers will give them the advice necessary, sir. And it is a lawyer who will say, listen, you could take a chance on this, you know, because it ain't going to happen, or it can't happen. But we don't want to go there. I strongly believe that people who earn should be paid and be paid on time. But I believe that we're in that scenario, as I said before, we have now become slaves of the situation, wherein we need to address the underlying belly of the beast. And until we get the cash flow in this country right, across the entire public sector, across the economic space, we're going to always have a situation like this. There will always be somebody who will not be paid. There will always be somebody who will not be paid. I know we're trying to address that by ensuring, but there's a harsh reality that we need to make sure that we go down that road, and we go down that road well. The concept of deductions, and because I've worked in so many companies fixing them, some I can't, but others I could, and I would have. The concept of a deduction comes down to cash flow. I can pay the person, but I can't pay the deductions. So it's not a matter that I've withheld something from you or whatever. Yes, in principle it is. But the reality, though, is on the cash side of the equation. So I'm going to pay you the basic because that's where you need to go to the bank and do what you need to do. And I'm going to fight it out with when it's NIS or VAT or BRA or whoever when it comes to the concept of the deductions. And a lot of times once you start to play that game, you can't come out of it. It is always a catch-up situation. And it's a never-ending hole. So this act, in my opinion, sir, this act puts us in a dilemma somewhat, because for a lot of people who have micro and small businesses, they now need to take stock as to what their employment numbers look like. The reality of whether or not I can make the pay. That is what the bill is actually saying to them. If you can't, the penalties are stiff. Consider whether or not you want to take the chance. And that's the conversation. So we all have to look at that and look at it carefully. There's significant implications for it, not just on the numbers as it relates to what we would want to talk about and the elements of it. So, there's a lot of studies that have been done as to why employers would have mispaid. There's a whole myriad of reasons why. But for the most part, they all start by talking about people miss payments because of cash flow. And then they go into all the other bad behaviors. So the reality for us is, how do we start that cash flow conversation so that it makes sense to everyone? What's going to happen on the government side? They will need to figure that one out for themselves, but we know how that works. There are statutory corporations in this country that when you check back in the records have not paid people. It is very, very, very simple. And similarly, on the private sector, especially in construction, there are a lot of people who don't get paid on a weekly basis, albeit that the terms, whether verbal or otherwise, would suggest that payment should be on a weekly basis. And as I said before, the reality lies in the whole concept of the cash. If people are not paid on time, then they cannot pay people on time. So somebody's got to break that cycle. Somebody has got to stand up and say, effective whatever day, we are going to start paying people on time. So that people don't have an excuse as to why they have not paid their workers, whether it be the government or the private sector, whether it be large construction companies or otherwise. So this issue comes down to the nitty-gritty of cash flow, in my opinion, sir, and one that we cannot sweep under the rug anymore, because the law has now exposed it, in my opinion, and it is one that needs to happen. Similarly, I would have heard comments before about imported labor. I smile at those comments because when you're on that other side of the equation, you understand that imported labor is about cash flow. When you have a contract at the very top, and you say, I'm going to squeeze that contract to the bare bones, and I'm going to give X or Y this amount, then where does it leave people? Exploitation would then occur because I'm going to go and get some fellas from somewhere, girls, I've seen ladies and men, they will come to Barbados and they will work for $5 a day. Why? Because $5 a day is something that they dreamt about. Never saw a $5 bill. In Barbados, I look at my wallet now, I might got $50 in my wallet just because it's, second currency of Barbados, so to speak. But this is the behavior that you have. So you start to have large companies going down that road because it comes down to cash flow, it comes down to finance, it comes down to what is the return that I'm going to get when I do put this money out there. And these are the harsh realities for it. So how do we address all of that as a small developing country? Is anybody's guess right now, but I know it lies pretty much in the mathematical calculation of economics and finance. Somebody has to break the cycle of pay. Somebody has to pay. If the government does not pay contractors on time, then contractors will not be able to pay their workers. It is just as simple as that. It's just as simple as that. I know people who make sure that they pay their workers to the expense that they don't take anything out. They live like paupers and they own the business. Should they really be in business? One could ask yourself that question. Should they really be there? But they employ 20 people and they got nothing out of it when the month comes because they're fighting tooth and nails, waiting on somebody to pay them. And that is where we are. So when I heard Senator Slocum today harping or going on about this phenomena about not getting paid. Well, it's a decision for him now. He is a small business person. He needs to determine whether or not he remains in that rat race or not. Because there could be a whole myriad of reasons as to why you get hired. And I've been in music business, so I understand what it is. People have the greatest expectations of what door receipts will look like. And on that day, that door receipts, with all the best plans, that don't materialize. And when that don't materialize, what happens? Lucky for the fellow who got his money first, but anybody now can pay. So people are old. The people who probably today in the industry who can look back and tell about when they were never ever paid and is lost in time. So we have to break that cycle to ensure that people are paid. So I will close by just simply saying, sir, that the situation is such that it warrants this act, this bill, pushes us towards another conversation, and a conversation that we need to engage and engage appropriately. People have to be paid so that they can pay people along the way and paid on time in accordance with agreements. We should not say to people, oh, we can't pay that bill this week, and he building my house, or find some excuses. And then all kind of people conjure up all kind of nitpicking of all kind of issues as to why people can't be paid. Oh, you didn't cross the T here. Look at the dot that you missed on the I. All of these kind of things like that. It should not be. It should not be. So as much as we want to put into legislation that employers should pay the employees as per agreement, then when the employer is an employee, he also needs to be paid as per the agreement and paid on time. So somewhere along the way, that has to be addressed, and I'm hoping, sir, that that can be addressed, that makes sense to this. Otherwise, I don't know what's going to happen the day that this is proclaimed, because I am sure that there are institutions in this country who will not be able to make that payday.
I know one.
And with that, sir, I would like to thank you for engaging me.
Thank you. Thank you very much, Senator Nels. Senator Odell.
Thank you very much, Mr. President. Good afternoon to you and all of my colleagues here today. Mr. President, like many others before me, I would also like to join in congratulating all of my colleagues in their recent accomplishments. Of course, Senator Archer and his team for successfully concluding and planning the crop over season. I am pretty sure that as a young person and new to job, he probably felt daunting at some point in time, but he proved that he was up to the challenge. So I want to congratulate him for that. I also, of course, have to congratulate Senator Slocum for his excellent performance. But I also, today, Mr. President, want to congratulate Senator Cummings for her work and her team in planning and organizing the ongoing away service that was truly fitting for our national hero. So I want to congratulate all of them. Truly A+ work coming out of our Senate. And Mr. President, today I rise to indicate my full support behind this protection of wages bill. At first glance, Mr. President, it seems to be a straightforward piece of labor legislation. As we've been hearing all day, it deals with how wages are paid, the deductions from wages, compliance and enforcement, and all these important matters. But I wish to go a little deeper because this bill is not only about the payroll, but it's about the people, dignity and fairness, but it's also about the rule of law, and most importantly, Mr. President, it's about recognizing that when a person has worked hard and honestly for their wages, those wages deserve the protection of the law. So, Mr. President, the first point I wish to make today is that wages are a human rights issue, not just a labor issue. And international human rights law recognizes the right to fair conditions of work. Mr. President, we as Barbados have signed on to several international human rights treaties, including the International Covenant on Economic, Social, and Cultural Rights, which entered into force for us in 1976. And this treaty, under Articles 7 and 11, it mandates that state parties recognize the right of everyone to just and favorable conditions of work and the right to adequate standard of living. And while we often think of human rights in terms of freedom of expression and equality before the law, economic rights are just as important because a person's wages are often the means of which they enjoy all of these other rights. You know, they need to eat, so they need to pay for food. They need somewhere to sleep, they need somewhere to live, so they have to pay for their rent and mortgage. They have to keep their lights on, their water on. They have to buy medication, Mr. President, to send their children to school. And when wages are withheld or delayed, it's not just a contractual dispute between the employer and employee, but the consequences extend into the home, and entire families feel the impact. And that's why I believe that this legislation deserves to be viewed not only as labor reform, but also as an important measure for the protection of human rights in this country. Mr. President, my second point is that I believe this bill recognizes something that is not often spoken about, and that is the existence of economic violence. When we hear the word violence, we automatically think about physical harm. But human rights law also recognizes that abuse can also be economic. And economic abuse and violence occurs when a person with financial power uses their power to control, disadvantage, or exploit another person. And for many persons, their wages are their only source of income. Not everybody has a comfortable savings to fall back on. And to unlawfully withhold wages, to make arbitrary deductions, to refuse to pay money to a person when that money has already been earned, is to exercise tremendous power over another person's life. Because, Mr. President, it determines whether that person can pay their bills. It determines whether they can eat, whether they can feed their families. It determines even if they can travel to work the next day, because if I ain't get paid, how I could put gas in my car, how I could buy or pay for bus fare to get them to work. And this bill recognizes and reminds us that exploitation is not always loud or dramatic, but sometimes it happens quietly. It can happen through one missed payday or through one deduction at a time. Mr. President, my third point today is that the rule of law must extend into the workplace. One of the cornerstones of every democratic society is that power should be exercised according to law and not according to personal discretion. And that principle should not stop outside of the workplace. Mr. President, an employer should not decide based on his or her convenience whether wages should be paid, when they're paid, and how much should be deducted. So I fully support this bill because it replaces uncertainties with clear legal obligations. It promotes certainty, it promotes transparency and accountability. And in doing so, Mr. President, it strengthens public confidence that employer and employee relationships are governed by the law and not by unequal bargaining power, because we all know that persons in Barbados believe that persons, especially that may be in the lower classes or persons who are vulnerable or who we might call the small fish, has no or little bargaining power. It's like, I ain't nobody, so who can listen to me? But this bill shows them that everybody's work and wages have value. Mr. President, my fourth point is perhaps the most important. Several persons before me today spoke about dignity, and I agree. Dignity deserves legal protection because behind every salary, there's a human story. Every pay slip represents hours that can never be returned. It represents early mornings and late nights, time away from your children, missed family occasions and birthdays, and hard work performed in good faith. And when we pass this bill to protect persons' wages, we're not just protecting their money, we are protecting the dignity of labor itself. We are affirming that the effort that people put into their work has value and deserves respect. Mr. President, as I said, I fully support this bill, but I wish to offer two recommendations that will make this strong bill even stronger. And the first concerns accessibility. I commend the inclusion of Section 19 of the legislative bill, which requires employers to communicate notices to employees with special needs in formats that they can receive and access. And this is a very important step forward. However, accessibility should not begin and end with notices. Of course, I commend the Employment Prevention from Discrimination Act, which prevents any person, from being discriminated against in the entire work cycle. But as workplaces become increasingly digital, accessibility should be embedded throughout the entire employer-employee relationship cycle. So I'm talking about accessible electronic pay slips, accessible payment portals, accessible complaint procedures, and just communication as a whole that particular person can actually use. And it depends, of course, on the person and what they need to access that information. And as a person who relies on accessible technology every single day, I know that for a fact, information that's not accessible is essentially information that was not provided at all. Because, Mr. President, if you decide now to give me a check for $1 million, poor me, I can't ever see the check, so I will not even know if it's a dollar for this $1 million. Luckily, I have technology, my smart glasses on my phone that can read text to me, but not everyone has that privilege. So I therefore encourage us through regulations to continue building on this important foundation so that accessibility becomes a normal part of workplace administration rather than just the exception as it normally is. Mr. President, my second and final recommendation might be a bit controversial, especially for employers. And I know we probably are not ready for it yet in this country, but I want to encourage us that sometime in the future, we consider making provisions for interest on the late payment of wages. Mr. President, this bill quite rightly strengthens the protection afforded to workers. However, Mr. President, when wages are paid late, the employee suffers consequences immediately. You may have bank charges. You may have late payment fees. You may have loan interest, Mr. President. Sometimes your utilities get cut off. In many cases, these losses arise through no fault of the employee. And this is not fair at all. And while this bill requires and allows a magistrate to award interest in certain proceedings, I respectfully suggest that consideration be given sometime in the future to providing that wages that are unlawfully paid late automatically attract interest from the date they become due to the date that they are paid. And Mr. President, this is not a novel or punitive concept. Many countries around the world recognize this, including South Africa, whose legislation, labor legislation, recognize that late payment of wages should automatically attract interest. And similarly, Mr. President, the ILO Administrative Tribunal has held consistently that interest paid on late salary is simply compensation for the time during which an employee was deprived of their money that was lawfully due to them. And as this tribunal has observed, Mr. President, the mere fact of delay is sufficient to justify interest, whether or not the employer was at fault. And this principle reflects fairness rather than punishment. And this provision will not only compensate the workers more fairly through the loss they would have suffered, but it would also reinforce the importance of timely payments and discourage untimely payments, untimely delays, Mr. President. Mr. President, this bill comes before us at a very important time. Workers today face increasing financial pressures. For many households, there is very little margin between one payday and the next payday, and I have seen it too often. A delayed wage is not simply an inconvenience. It can mean, Mr. President, that I don't eat for the next couple of days because my refrigerator is empty. It can mean that I miss my mortgage payments. It can mean that the electricity bill is overdue. It can mean that I can't purchase my medications. And that could be very, very disastrous to a person's health. And this reminds us why legislation like this matters. Mr. President, as I close, I wish to say this. Mahatma Gandhi is often attributed as saying the true measure of any society can be found in how it treats its most vulnerable members. But I say this, the true measure of labor legislation is not how it treats the employee with bargaining power, but is how it protects the worker who has none. The young employee entering workforce for the first time, the single parent struggling to support their family, the migrant worker who may not understand the laws, the worker with a disability who simply just want communications in a format they can access. And this bill tells each and every one of those workers that we hear them, we recognize them, we understand the value of their labor, and that the law will stand behind them to make sure that they can receive what they honestly work for. And for those reasons, Mr. President, I am pleased to fully support the Protections of Wages Bill 2026. And with that, Mr. President, I'm obliged. Thank you.
Thank you very much, Senator Odell. Senator Maladu.
Thank you, Mr. President. Good afternoon, everyone. I see Leader of Government Business, Lisa Cummins, has returned to the chamber after a brief absence, and I wanted to, Senator, it was long. No, it was very brief. I just wanted to say, as I stood up, I heard that many people have congratulated different people around here for the activities over crop rover and so on. I managed to stay out of all of that troublesome areas, but I did attend the funeral of our national hero, and I want to personally congratulate Senator Cummins as the leader, I believe, of the organizing committee. That was a fantastic tribute. Fantastic. Now, let's turn to the matter at hand here. I had only planned to say 3 things, but I've been so inspired by so many people around here. So inspired that they inspired me to stand and speak to you at 4:35, 4:38. Let me start with, Mr. President, by quoting my newest and dearest friend, Senator Trim. Good employers deserve a level playing field. I could not agree with you more. And what we cannot do is just simply harp on this legislation as if we have a lot of bad employers in Barbados. There may be a few who breach the rules. And I must say that I am extremely disappointed in this country that we even need this legislation, because I thought this was pretty obvious, sir. I thought this was obvious. You ask someone to do a job for you, you pay them. But that equally applies to the private sector, the government sector, to contractors, to employers. So don't let us just talk around here about 1 or 2 bad employers who make a deduction and don't pay it over. The reality is that what Senator Niles spoke about is that many of these employers, contractors, are waiting on payments from the government. This is a problem. And I have been shown, as I was sitting here, pseudo-government agencies who regularly send out notices saying, we are going to be late. We're waiting on payments to come. We can't pay our people. The other thing that I would like to say is, Senator Goodrich, you make an excellent point with regards to this idea of we still have to go to a bank to withdraw money. There's ATMs everywhere. But guess what, Senator Goodrich? It's a good thing that this legislation was not enforced when we introduced BIMPay. Because I can tell you, as an employer, that a number of my employees did not receive their money as a result of a failure of technology. Now, we're trying to do a good thing with BIMPay, and we had some teething issues. But there is nowhere in this legislation at all that recognizes that the failure of a technology or the failure of an intermediary to process the payment in a timely fashion is an excuse, as others have said. So I am worried a bit about that as well. Again, I haven't even gotten to the 3 small things I wanted to talk about. But the truth is, sir, that coming from the private sector, I can tell you that the thing that I believe that the most employers really keeps them up at night is how are they going to pay their employees. They hold this dear to their heart. And the last person generally within the private sector to get paid is the owner of the business. They lose sleep over it. They do everything they can. And as Senator Trim said, good employers deserve a level playing field. And I am concerned that, as I say, I thought this was what is stated in this bill would be general good behavior that we would expect in Barbados. So it's unfortunate that we have to continue to legislate things like this. But I support everything that's in the legislation. 2 things, though, that I would point at. I think that when you have small employers who perhaps have 3 or 4 monthly paid employees and 1 hourly paid employee, mandating that that person must be paid weekly is likely to place a burden on those small employers that's unnecessary. And I think this legislation would have been better had it have said that you cannot pay any less frequently than monthly, but you could contract with your employee, who is an hourly paid employee, to pay weekly, fortnightly, or monthly, but mandating in the legislation that it must be paid in a certain way, I think actually takes away some of the rights from the workers to agree to something different. And I think that that was an unnecessary provision, and I hope it will be looked back at, because I wouldn't object to this legislation on the basis of that only, but I think we could have done better. The other thing I would look at, which does worry me greatly, so if you listen to anything else, nothing else I say, perhaps listen to this. I think that this legislation is extremely weak in separating what are legitimate loans that good employers give to their employees from time to time from an advance in wages. What this is going to have an unintended consequence of doing, and let me paint the scenario so that we're not confused by it. As an employer myself, and I have been in the position as being an employee and finding myself in a bind and needing some money from somewhere and going to my employer and saying, look, my children's school fees are due in September. I am short. Could you lend me $2,000 or whatever it was? I will pay it back to you over the next 4 or 5 months. I can almost guarantee you that every good employer in Barbados has had that question asked to them, and they have answered in the affirmative, and they have made an arrangement, maybe on a little letter, that says, over the next 6 months, this is what you're going to pay this back, and I'm going to take it out of your wages. Yeah. Unfortunately, this legislation puts an end to that, an end to it, because it does not differentiate between an advance in wages and what is a loan. The only ones that can do that is if you're in the business, so you're in a bank, you can have a legitimate loan with someone who's an employee of you. Otherwise, if you're not in that business and you simply do what we have all done as good Barbadian employers for many years and help out that employee in need, you are in trouble. You are in trouble because you cannot deduct it in this way. If that employee leaves within that period, that money is gone. You have absolutely no way, as the law is absolutely clear on it, you have no way of ever getting back that money. So what this is going to do, unfortunately, is even a good employer, which I consider myself to be, is I will have to look very carefully when someone asks us now, even in the most, and I had one recently, I hate to say that we had to do it. We had an employee who had a child who was ill and they had to go overseas. We all jump and we help and we donate some, we lend some, we do whatever. But under this legislation, it is going to make us think very carefully about that because we cannot recover it, and it is a flaw in this legislation. If we don't fix it, I'm afraid that the unintended behavior is that employers are going to simply say, no, under this legislation, I have no way of recovering it from you. I can't recover it forcibly through the wages. If you leave here, I have no way of recovering it. So that worries me. Sorry, the last thing I was going to say is I must say that when I read this, you can't read the Protection of Wages Act. I think it was one of government senators who pointed out the interaction with the Insolvency Act, or perhaps it was the leader of government business herself that said it. But in my reading, in order to understand this legislation fully, there are at least 9 other pieces of legislation that have to be read in conjunction with this to understand the totality of the situation. Those include the Employment Rights Act, the Minimum Wage Act, the Holidays with Pay Act, the Severance Pay Act, the National Insurance and Social Security legislation, the Bankruptcy and Insolvency Act, the Public Service Act, and indeed the Exchange Control Act. So why did I say that, sir? I say that because I think that having these disjointed pieces of legislation creates some confusion, and there's going to be some difficulty with how they interact with each other. And I'm asking for, in the future, for consideration to be given for us to develop an overall comprehensive labor code that would encompass all of these matters now that are in all of these different pieces of legislation into one area that would make sense for us to look at. So, Mr. President, having made those points, I would just go back to one last thing to say. I heard the last senator who spoke to call on interest to be paid on salaries when they're paid late. I have no problem with that, as long as we find the parity, and as Senator Trim told us, for good employers to deserve a level playing field, and that for those contracts when they are paid late, for interest to be paid on it, or VAT refunds to be repaid with interest, and all this. I agree with you totally, Senator Trim. You have my full support. And with those few words, sir, I'm obliged to you.
Thank you very much, Senator Maladu. Senator Benjamin.
Mr. President, good evening, and good evening to our esteemed guests. I hope that this will not be considered bad manners, but permit me, Mr. President, to start with my contribution with a question. And the question is just for consideration. What exactly is a wage? And this is a question that came to my mind as I was perusing the bill in preparation for today's debate. And it might sound like an odd question coming from someone who practices in industrial relations, and therefore wages and the talk about wages is a cornerstone in the work that I do. But as I considered it some more, I came to the conclusion that there is no one correct answer, and that it depends on who you ask. So if you ask an accountant, for example, they may say that a wage is an expense, is a line item. If you ask a business owner, they're likely to tell you, as they often do at the negotiation table, that wages are the biggest carrying cost of a business. If you ask an economist, they will tell you that it is the price of labor. And all of those answers, in my view, are technically correct. Like I said, it depends on the person to whom you're asking the question. But a few weeks ago, I don't want to call it an opportunity, but I found myself engaging through the work with the Barbados Workers Union on a construction campaign. And in conversation with some of the workers, conversations about wages came up. And those of you who have ever had the opportunity to go on a construction site early in the morning, you would understand that as the men are getting ready for the day and they are lacing up their boots, preparing for a day in the hot sun, the kind of conversations that they're having, they're not pretentious in any way. They are honest, and that's exactly what we got as we engaged with them. So in the conversation, one of them looked to me and they said, Mrs. Benjamin, every time I receive my pay slip, I notice that there is a deduction for something called a retention fee. And he indicated that he did ask some questions around it from the employer, and the employer explained that this is a fee that they take out of your wages, so what you've already worked for, and it is them essentially buffering themselves in case you do not complete the contract. In the event that you complete the contract, they would repay you the money. But in the event that you determine that this type of work is no longer for you or you want to go back home, they keep the money. So he was asking me, Mrs. Benjamin, is that something that is allowed?
And so I answered him because that is what I'm trained to do. So I had to answer him. But if I'm being truthful, it wasn't his question that followed me home that morning. It was what the question revealed. I kept thinking to myself, but how did we get here? How did we get to a place where somebody could describe in such a cavalier manner that these things were being deducted from his payslip? As he was speaking to me, there was no anger, there was no outrage. It was just as though this was another ordinary part of work and work life, and he was just kind of querying it. And I think it's important for me to say that at this point, he was working with the company and this retention wage was coming out for more than 18 months. And that situation, Mr. President, made me wonder what the true danger is that we are facing. Is it the injustice in and of itself? Or is the true danger that we are becoming so accustomed to certain practices that we stop questioning them altogether? Often as we engage with workers, you hear workers say, but that's just how it is. That's company policy. That's just how things work. And I want to take this time to remind Barbadians that that cavalier approach is not our history. Senator Trim made mention of it, but recently I have been looking more deeply into our history. We recently came from the National Day of Significance and Emancipation Day. Perhaps those are the things that are weighing heavily on my mind now. But every advance that we now take for granted began because somebody refused to accept that that's just the way it is. The 8-hour day that we've grown so accustomed to, it didn't happen because that was the status quo. Paid leave did not come about because workers stayed silent. Maternity protections did not come about because Parliament woke up one morning with a brilliant idea. Every single one of these advances began because somebody had the courage to ask the question why and to push back on it. And it is my submission, Mr. President, that that is what this bill is asking us to do today, again. Not to simply approve another piece of legislation, but to look honestly at the practices that we have become so familiar with accepting. We often imagine that history is something that lives in museums or in old photographs, in legislation that has long since been repealed, but I don't think that's true. I think history has a habit of lingering. Sometimes it survives in attitudes, in our mindsets, long after the laws themselves have been repealed. And we celebrate, and rightly so, that we have repealed the Master and Servant Act. We passed that era. And we should celebrate it because that chapter is long behind us. But every now and again, I find myself wondering if we have completely left behind the mindset. Because whenever I hear that one person can decide entirely on their own whether another person receives wages they have already earned, I hear something that sounds uncomfortably familiar. Not an echo of the legislation, but an echo of the thinking, the mindset. One of the first principles we learn in law is that no one should be a judge in his or her own cause. And that principle is so fundamental that we rarely stop to truly think about what it is telling us. We accept it because we understand that wherever power exists, there must also be limits. So if we understand that, help me to understand why in a workplace setting that should be any different. Why should one party be allowed to investigate, decide, and impose the consequence all at once, Because essentially, if we think about what that worker shared with us, with the retention fee, that's what the employer is doing. He's protecting himself. He is making sure that there is no risk to the business and that the employee carries all of the risk. Mr. President, this bill also forces us to think about payday. And that may seem very simple to those of us who perhaps make enough that we don't even know when we get paid. But for too many ordinary Barbadians, that is not the reality. And sometimes we talk about living paycheck to paycheck, and it starts to sound very cliche. So I really want us to recognize, because the reality is many of us around this table may not truly understand what that means. For a lot of Barbadians, it is the day everything else depends on. We say people living paycheck to paycheck. It is the day where the mortgage continues to wait, the rent continues to wait, the credit union deduction continues to wait. And if we're honest with ourselves, somehow the supermarket too is waiting. Anybody who has ever walked through a supermarket calculating in their minds the cost of items to determine when they need to stop would understand exactly what I'm talking about. And that is not poor planning on the part of the employees that we're speaking about. That's simply their reality. And that's why I struggle somewhat, Mr. President, whenever delayed wages are spoken about, as though they are little more than an administrative inconvenience. Whenever workers call the union to say, well, they haven't been paid as yet, and we pick up the phone to call the employer, the first thing we hear them say is, oh, but payroll was processed. Oh, but perhaps it's just the bank has delayed the transfer. It should clear by tomorrow. All in a very cavalier type of approach, as though people's lives are not hanging in the balance. And I'm not saying that sometimes those explanations aren't genuine, but every time I hear them, I find myself asking the same question. Who is carrying the inconvenience? It isn't the payroll department explaining to a landlord why the rent is late. It's not the finance manager who's calling the credit union asking for more time. It isn't the employer who's standing in the supermarket deciding which items they can afford to take now and which ones they have to come back for next week. It is the worker who's bearing the inconvenience at all times. And that is exactly why I welcome the provisions dealing with recurring pay periods. So by mandating that there are recurring pay periods, we are finally recognizing that certainty has value. In my line of work, I've come to realize that certainty is one of those things that you don't appreciate until you do not have it. When people know when they will be paid, they can plan their lives differently, they can make commitments differently, they can budget, they can save. And so I don't see these provisions as mere technical amendments. I truly see them as us being able to impact the lives of working people positively. Mr. President, I want to move now to the point on financial institutions within the bill. As I kept perusing the bill, the worker's right to choose the financial institution into which wages are paid caught my attention. I didn't hear specifically any of my colleagues speak on it, but for me, it caught my attention because I learned that over the years, the things that we call small issues often tell us the most about how we view people. I never understood why accepting employment at one place determined where I must bank. And the reality is that that is so common. I didn't know that and I didn't understand it until I started working in the environment of the trade union, where employers want to mandate, well, if you're working here, you have to open an account with X bank or X credit union. And this bill puts a stop to that. So as I digested the provision a little further, I was reminded of a matter that I dealt with a few years ago, where just before Christmas, a worker was accused of receiving an injury benefit from NAS. That worker worked for a credit union in this island, and the employer's approach was to freeze the account of the employee. Unfortunately, the account was a joint account, and so it impacted the entire family. That Christmas was something that they were not able to enjoy. And this bill also speaks to that, because it says where there is a financial institution that they do not have the power to interfere with the employee's account. People sometimes assume that because I'm an attorney, I see the law first. And perhaps 6 years ago, that may have been the case. But working in the trade union movement has truly changed me. And somewhere between the conciliation meetings, the negotiations, the construction sites before sunrise, and the countless conversations with ordinary working people, something in me shifted. And now I can say that I truly see people first. I still love the law, and I always will, but I've come to understand that the law only has meaning because of the people whose lives it touches. And I think that's why the next part of the bill that I wish to touch on resonated with me in the way that it did. I want to touch, Mr. President, on the third-party deductions. That doesn't sound like a provision that would normally attract much attention either, but it's the kind of clause that people skim over because it feels administrative. I recently heard one of the consultants for employers recommend to the employers that they just stop doing the deductions altogether. Like, the position that was taken was, this bill is going to cause you too much administrative burden, so just don't do them. And I feel obligated, Mr. President, to speak to that today. When we speak about third-party deductions, we are speaking about the ability for people to thrive. You cannot get a mortgage in this country easily without being able to have that deduction made. You can't even go to court sometimes for hire purchase without them wanting a deduction from the employer. And so if the advice that is being given to employers now is to just don't do the deductions, I think that we're doing Barbadians a disservice, Mr. President. If we make it harder for ordinary people to invest or to access the mortgages, to maintain insurance, to build good credit, then what exactly are we helping them to build? What kind of working life are we encouraging? One where people earn but can never advance in life? One where people receive wages but can never accumulate wealth? I don't think that that's what we want. And the reality is, Mr. President, working class people are not asking for any extreme wealth. They just want the dignity. They want to be able to live a comfortable life. They want to be able to own a piece of the rock. People aren't asking to become rich. Mr. President, the next point in the bill, actually this one was not in the bill. I think this one was first raised by my friend Senator Walters when he spoke about the labor shortage. There's been a lot of national debate around Barbados having a labor shortage. And perhaps in some instances we do. But after spending so much time in the fields, because that's what we do in trade unionism, we go to the people where they're at. what I've recognized is that young Barbadians are asking themselves different questions. Our young people are not asking, can I find work? Mm-mm. They want to know whether or not they can find work that will allow them to build. They want to know if they can find decent work. They want to know if they can find work that will not exploit the labor for minimum wage. And I think that that's an entirely fair question. Employment is supposed to create opportunity. Employment is supposed to make independence possible. It's supposed to allow people to build their families, to own their homes, to educate their children. So entirely, Mr. President, it is a question about dignity. I pride myself on being fair and just. And so I know there may be someone listening to this debate and saying, well, Kamisha, that's all well and good, but there are some businesses that are struggling too. And I accept that that's a reality. Some are. I've been in rooms where the conversation has changed. Only yesterday I received a phone call from some members who were saying that the employer has signaled to them that they're going to close down. And those conversations are never easy to navigate. And as a trade unionist, those are not conversations that we like to hear. We believe that businesses should be sustainable while still ensuring that employees are treated fairly and with dignity. This bill, however, makes sure that in these hard circumstances where a company has to close, the workers are treated with priority. And that is something that I wholeheartedly agree with and support. The final point, Mr. President, that I wish to make is that you often hear people speak about foreign investors coming to Barbados. And that is something that we support. I certainly support it. However, it should not come at the expense of our labor standards. Barbados has prided itself on setting standards that are way ahead and advanced of many of our sister nations and brother nations. But the reality is that sometimes foreign investors do come to the country and expect to be able to treat to the workers in ways that they are familiar with. But it is very important that we maintain the standards, and this bill is one that will confirm to foreign investors what the standards are. In respect, Mr. President, of the penalties, I want to make just one quick point. When wages are owed and a matter has been brought before the court, the magistrate has a discretion. The discretion is either to, there is an option for the employer to be financially punished or imprisoned. But what this bill does is to make it very clear that the magistrate still has a discretion to make the employees whole. So in other words, if an employee goes to the court with a complaint, the magistrate does not have to do one or the other. They can punish the employer with the fine, but they can still make the employee whole by ordering the company to pay the employee what is due and owing to them. And I'm making this point because based on my experience and my knowledge of how the protection of wages bill in its current state is currently treated to, magistrates make a choice of which one they will do. And oftentimes, they go the route of punishing the employer, but that means that the employee never receives what is due and owing to them. But I'm very grateful to see that in this bill, it makes it extremely clear that they can do both, and that it is within the magistrate's purview to do both. Mr. President, I've said before in this honorable chamber that fairness and dignity must remain at the center of national development. Development cannot simply be measured by the number of buildings that we construct, or the size of our economy, or the level of investment that we do attract. Those things do matter, but they are simply not enough. The real measure of development is whether the people whose labor created that progress are themselves able to share in it. In my view, Mr. President, there is something that is fundamentally wrong if we can celebrate a new hotel while ignoring whether the people who built it can afford a decent home. There's something unsettling in my spirit, Mr. President, about celebrating economic growth if working families remain permanently in crisis. Mr. President, growth has to be felt and not just reported. And if there's one lesson that I hope we take from this bill, it is that our responsibility cannot end with protecting the workplace that we inherited. Mr. President, I believe that every piece of legislation that comes before this Parliament should answer one simple question. Does this make life fairer for the people whose work builds this country? Not if it makes it easier for the government, not if it makes it easier for employers, and certainly not if it makes it easier for trade unions. The question is, does it make it fair for the working people in this country? I honestly believe, Mr. President, that Barbados will continue becoming the kind of country previous generations hoped that we could be, and I believe that this bill is a step in the right direction. So with those few words, I commend this bill to this chamber.
Thank you very much, Senator Benjamin. Senator Singh.
Yeah, Mr. President, I joined this debate not to be very long, even though somebody once said brevity is a function of knowledge. If you don't know much, you can't talk for very long. But I hope that is not my play today. No, I just wanted to make a couple of points, and I want to thank all the senators who spoke. I think it is a very important piece of legislation. It really sits consistently with the posture of the Barbados Labour Party and the administration in government and out of government for a number of decades, from the time of Grattley Adams, now, of course, right excellent, to Grattley Adams, National Hero of Barbados, for the formation of the Barbados Labour Party out of the, really coming through the riots of 1937, all that happened before, the depression of the early 20s, the riots of the 30s, the Moyne Commission, all of those things. I think it has, yes, it has led us to a space where over time, almost in successive decades, we have had legislation coming to this Parliament to empower workers in this country, and certainly to protect them, not just to empower them, but to protect them. And I think that is a record that is worth highlighting and trumpeting. And therefore, I have no difficulties in saying that whatsoever. This piece of legislation now gives additional securitization for workers in terms of their wages. And I think it is something which I doubt we will get any divide here, even though there may be aspects of it that people may want strengthened, may want greater clarity, or even some clauses that people may not necessarily agree with. I think the point is that, in general, it is an excellent piece of legislation, and I think all Barbadians should be proud that the administration that they have given 3 consecutive terms to, with all of the seats, can still be grounded enough to know, plus 2 by elections, if you may add in the 2 of those 2. Yeah, but I have to. To give you, I mean, you know, that arrogance has not set in, that people have not abandoned the working class or workers, and that the government will take time, the administration will take time to keep faith with the people who have put them in office. So I support this legislation to its max. There are a couple of things that I thought, though, that maybe would be worth saying. You know, there's a saying that with great power comes great responsibilities. And you can put it, yes, that's true too. Power corrupts and absolute power corrupts. But let me put it a different way. With great securitization in your position comes great responsibilities. And whilst we say to workers that we as an administration are going to be with you, are going to protect you, are going to ensure that your wages, as much as we can, guarantee, will be securitized. Because that ought to happen. Fair day's work, fair wages should be protected. It also throws up responsibilities for workers. Now, we speak about a lot of things, but one of the things in Barbados that we really do have to pay attention to, and this is not just tied to the fact that we are perhaps in the depopulation phase of our development, something that we have to look at, and I heard senators, honorable senators speaking about the lack of skills in different areas, but it's also the issue of productivity. Productivity. And for many Caribbean territories, we have seen, this is not just a Barbados thing, we have seen that productivity levels have not necessarily kept pace with the rest of the world, particularly in some of the developing world in particular. And we know Barbadian workers are very productive. We know that. We know that Barbadian employers would like their workers to be even more productive if they can get so. But I think that we have a responsibility, employers and employees, to ensure that we not just protect and securitize wages and even earnings, as far as those can be done for employers and business people, but that we ensure that these things are deployed in such manner as to allow for us to increase productivity. That is, and the reason why I'm making this point is this. This is the protection of wages. But there's something else that goes with wages. And I think Senator Benjamin was speaking about it in a particular way from her perspective as a trade unionist. There's something called conditions of service. Wages is one thing that we are securitizing today, good thing to do. But I want to suggest that levels of productivity that we aspire to and ought to have as a developing small economy, aspiring to go to a different level of operation, of production, cannot be achieved realistically. If you pay a good wage, reasonable wage, securitize it and ensure that it is paid every time there is a pay period, but the conditions of service are just not good enough. So this is one part of it. There are other parts that we also have to pay attention to. And when I'm speaking about that, I'm not talking about some of the things that we've seen recently and I've heard recently. That's part of the thing. But I'm talking about everyday conditions that workers have to get up to and go to work and experience that can lead to frustration, low morale, and a feeling that this is not something that I'm doing it just to get the wage. because I have to pay my bills, but I'm not doing this because I'm enjoying it. And that is when productivity starts to fall, because people then lose interest, they then reduce their effort. And I'm saying that as we securitize wages, I know that this administration is also looking in different aspects at how we improve the condition of the worker in the workplace. The provision of equipment, of gear, something simple. I'm here next to the minister responsible for technology. Something as simple as somebody coming to work who is a clerical officer using a computer, iPad, laptop, whatever the case may be, and working with an insufficient instrument tied to an inefficient Wi-Fi system can be wholly unproductive for that whole day. Not because the person does not want to work, but because the conditions under which they're working, the tools with which they're working, are not up to scratch. And I think that is very important for us to look at. We talk about buildings, sick building syndrome, for example. People are made to come to work in conditions that could be hazardous to their health. The salary is securitized, but the condition of service causes them to have to be at the doctor with all kinds of respiratory illnesses. And of course, Senator Connell and his colleagues will tell you about those. They see them often. Some of them have to take time off, considerable periods of time, because nobody's minding that particular part of the shop, but the wage get paid. And the productivity does not increase, or in fact, it suffers. These are things I think we have to pay very close attention to. So I don't want to belabor the point too much. Third point, Mr. President, is the issue of pensions. Now, I looked through the legislation. I don't see it copiously covered here. In fact, I think it makes reference to other enactments, which, of course, would speak to those things. But I want to make the point when you're talking about protection of wages. When you deduct from employees' wages to pay into a pension fund or pension scheme or whatever the case may be, that is still wages that have been deducted. And those wages are in lieu of pension to be deferred when the person is retired. We know of circumstances in this country, both in public and private sectors, where pension schemes are under pressure. Some have collapsed. Some have gone out of business. And therefore, the question is, how do we ensure that those persons do not fall by the wayside in terms of what may confront them down the road? And it is not something that I think anybody is necessarily doing wickedly or nefariously. It is that the fundamentals, the financial and economic fundamentals, over time have caused a lot of the pension schemes, based on a particular model that we have used, to come under pressure. And that also is something that we have to concern ourselves about relative to how deferred wages, because that's what that is. Your wage is deferred in a pension scheme for when you retire, and so you have it available to you. The final point that I want to make, and I think this is not anything original. In fact, there's no original thought, not even from Adam and Eve, I'm told. But I heard Professor Winston Moore making this point recently at the credit union function event. And this is about, because we're speaking about employers, and we are protecting the workers and ensuring that the employers do what they have to do and so forth and so on. But they got some sharks in the waters who circle around a lot of workers. And they may get their salary from the employer on time, securitized by this and other pieces of legislation, but there's some people out there who are really offering product or services or instruments that do not that can unmake that securitization very, very quickly. And it is something that we have to it is something that we have to be very careful of. Now we have governing institutions, well, not the central bank so much, because I don't think the central bank does that, but the FSC, the Financial Services Commission, the FSC does non-bank institutions that are offering these things. Now, Professor Moore complained about it and suggested that a lot more of this should really be done by the credit union and other institutions that would have the workers' interests at heart, and I agree with him. But it is something that we have to look at, and that this administration, I believe, started to look at very seriously, because you have a situation where a person can work very hard, they can be productive, they can get their salary on time, but end up in such situations where, because of the pressures that we have all identified here, as they thought, the paycheck to paycheck, the difficulties that people to have them in a situation where they may, because of lack of information, lack of sophistication financially and so forth, make deals or go and get loans or other provisions that come back to really undermine all of the wonderful work that's being done by this piece of legislation. And I think these are things that we really have to ponder on. I know that we've done, this administration has done through the Ministry of Commerce, small business development and so forth, courses in terms of financial literacy and that kind of thing throughout communities. That is important and has to continue. But I think at some point in time, the state may have to intervene at a more robust level to offer those levels of protection to supplement what we have here in an employer-employee relationship, because those things fall outside of that particular juridical relationship. So I think that those, Mr. President, I didn't want, as I said, I didn't want to be long, but I think that those points rested on my mind as I heard other people, other senators contribute to this debate. But once again, excellent piece of legislation. The people who have put it together ought to be congratulated, and the government, of course, itself ought to be congratulated for bringing this forth at this time, because it is much needed, and I believe it will be very well received by the wider community of workers and unions in Barbados. I am obliged to you, Mr. President.
Thank you very much, Senator Sinclair. If there are no more speakers, I'll ask Senator Cummins to wind up.
Thank you very much, Mr. President. I am going to be very brief in my wrap-up, first by thanking all honourable senators for their contributions. I also want to acknowledge the various points that have been made by those who spoke on behalf of Labour. There is entirely a different perspective that you see once you are on the inside of the industrial relations environment, which we would not see on the outside. But equally, there are those perspectives that you would see when you are the employer or when you are the small business owner, when you are not just the employer, but that business is your livelihood. That's your life's work that you've built. It means something to you. In the same way that we accept that this is about the dignity and the protection of workers' rights. And so there is no tension, and I was very clear when I said that in my opening. There is no tension, neither is there no linear approach that can be taken to protecting parties on all the sides of this debate. But it is important that in the pieces of legislation that feed into this, all of the pieces of legislation, whether they fall under the BRA, the NIS, under labor, industrial relations, that these are all important pieces of legislation. And I thank all honourable members for their contributions. With these few words, I beg to move that this bill is read a second time.
The question is that this bill be read a second time. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Senator Cummins.
Mr. President, I beg to move that Your Honour do now leave the chair and the Senate resolve itself into committee for further deliberation on this bill.
The question is that they do not leave the chair and the Honourable the Senate resolve itself into committee for further consideration of this bill. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it.
The Honourable, the Senate is now in committee.
Madam Deputy President, permission to take the bill in parts?
Permission granted.
Clauses 1 through 10.
Madam Chair, I beg to move that clauses 1 through 10 do now stand part.
The question is that clauses 1 through 10 do now stand part. Will all honourable senators in favour please say aye? Those against please say no. I believe Senator Goodrich.
Yes, ma'am. So, ma'am, I just wanted that when we go to clause 3, 11B, 311B, where it states that a method other than cash, including through a deposit account held at a financial institution, the employer shall allow the employee a reasonable period to convert the payment to cash at a financial institution during the usual hours of business of the financial institution. My recommendation would be that the Act should define a reasonable period, and if the intention of the statute is to only refer to checks, then it shall explicitly state that.
Senator Allen, please.
Yes, ma'am. I've heard the goodly senator. The reference to reasonable time, which I understand to be her complaint. I don't wish to misquote her, but the reference to reasonable time within the legislation is in keeping with legislative practice for these types of circumstances. One, you are not going to have a situation where you will dictate for any judicial party who has oversight of the legislation what circumstances may arise. Also, there's no suggestion as a correction that I believe will fit the circumstance. So I don't know what is the proposal being put to committee. And in the circumstances, I think it is totally unnecessary. There's no highlighted failing that calls into question this specific section.
Other honourable senators? Senator Goodrich, please.
Ma'am, time limits is not foreign to statutes. So even if we say that there's a period, say, no longer than 3 hours or something like that, I believe that we could use our, intellectual minds to come up with something. It is not a bad recommendation.
Honourable Deputy, yes, ma'am. I do not believe it is appropriate for us to be seeking to place any mandate within the legislation. There's a controlling reference to the operating hours of financial institutions. And I believe that there's a reason why there's a controlling reference to financial institutions, because they have certain business hours. We do not want to limit the circumstances of employers who may wish to dictate what is reasonable based on their particular job description of the person, the requirements of the entity, and the like. I think it will be an inappropriate constraint.
The question, therefore, is that clauses 1 to 10 do now stand part. All honourable senators in favour, please say aye. Aye. Those against, please say no. The ayes have it.
clauses 11 to 25.
Madam Chair, I beg to move that clauses 11 through 25 do now stand part.
The question is that clause 11 through 25 do now stand part. Will all honourable senators in favor please say aye? Those against, would you say no? Senator Goodrich, I believe you seem to be saying no?
Yes, ma'am, of course. So, ma'am, I recognize that in section 14, that, yes, ma'am, 1-4. One of the things I recognize is that the bill has been silent on the time limits on recovering overpayments. So section 14 allows an employer to recover an overpayment or duplicated benefit from future wages, but it sets no outer time limit on how far back that recovery can reach. A reasonable limitation, such as 6 months from when the overpayment is discovered or reasonably to have been discovered, needs to be added so that an old payroll error cannot resurface to the hardship of a worker who has long since relied on that money in good faith.
Honourable.
And also,
Senator Goodrich, you have the chamber's full attention.
same clause, section 14, I believe that a more balanced approach would permit larger recoveries. As in my speech today, I had mentioned the example by stating what happens if a worker is overpaid by a very large amount, 100,000. You know, and then the legislation is basically only allowing that employer to recover 1/3. So I had a note here where it states a more balanced approach would permit larger recoveries where the employee agrees or allow the tribunal to approve a reasonable repayment arrangement in exceptional circumstances involving substantial overpayments. So I believe that the legislation could be, amended to reflect such exceptional circumstances. Thank you, ma'am.
Senator Aline?
Yes, ma'am. I believe my friend may be making reference to an earlier form of the subject legislation. There is a section 4B which limits the recovery to within 1 year of the date of the overpayment. So I do not believe that her reference is correct. The latest form of the bill has that section. In relation to the second point made by the senator, I think there must be some cognizance of the nature of this legislation, what it's seeking to protect, and the most likely scenarios that will occur in real life. The idea where an employer can either coerce, convince an employee to sign away the ability for them to take out more than 1/3 of their wage is not something that that should be appropriate in this type of legislation. This is about the protection of employees. The 1951 legislation would have limited the amount that you can take out of any one paycheck, and it makes sense in the context of the existence. And many of the members here would have referenced the impact of wage deductions not being paid timely. You cannot have a situation where a person is going home, as we hear on occasion, with nothing or $100 out of a paycheck with a family to feed and the like. There's a reason why the legislation is in the form that it's presently presented. And I do not think that the scenario which the goodly senator has put forward is something that needs to be addressed in legislation. In this modern world, an incorrect transfer, bank transfer, there are many ways to deal with it, such that there's no issue of an employee being able, unless they move very quickly, as Senator Cummins said, and then we'll be putting it into a different realm where there are criminal elements to take care of those circumstances. So I do not consider that a necessary amendment to the legislation.
Ma'am, Senator Goodrich.
I disagree with my goodly friend because the legislation is not there to create any level of unfairness, ma'am. So where we, as goodly senators, could make amendments to suit foreseen circumstances, we should do so. Because we can't say that it won't happen, because I already told you, it does happen. Overpayment is something that can happen. Cents can be mixed up with dollars, and that is something that can happen. People are not perfect. Payroll officers can make mistakes. And you know what? If we don't make the amendment, or something like that happens, I hope that Barbados will remember it was I that said to make the amendment.
Is it you, Senator Aline?
Yes. Ma'am, my friend should be assured that Barbados will remember it is I, because she has made any number of contributions that are very unforgettable. Now, the reason why they may be is questionable, but they are certainly unforgettable. I believe that Senator Goodrich did not necessarily understand the point I was making, which is not that this is a foreseen circumstance which we are leaving uncovered. I was suggesting there are any number of existing circumstances that can take care of what she has highlighted, and there's no need for this legislation to address it in the form as suggested.
Thank you very much, Honourable Senators. I must tell you, by way of anecdotal commentary not asked for, that I once got a payment that should have been $25,000, and somebody made an error and added an additional zero. And so $250,000 was sent to my account. I was in New York at the time, and I called the people quick and said to them, I beg you, the Minister of Finance named Chris Sinclair, get that money out of my account. The question is that clauses 11 through 25 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Madam Chair, I beg to move that clauses 26 through 33 do now stand part.
The question is that clauses 26 through 33 do now stand part. Will all honourable senators in favour please say aye? And those against? Aye. Senator Goodrich.
Thank you, ma'am. Clause 28, subsection 1. It does state that sections 2 to 19 bind the state, and for the purpose of those sections, employer includes the state and any public officer or employee acting on behalf of the state in its capacity as an employer. Now, I know that the leader of government business, she had alluded to the fact that the entire statute binds the state. So, for the purpose of every citizen of this country, I just need to know if that there needs amending to really state that the entire statute should bind the state, that will be inclusive of the offenses in section 25. Thank you.
Senator Aline.
Well, if she's asking me the question, no, it doesn't need amending. uh, the Honourable Senator should take cognizance of, I cannot countenance the numerous pieces of legislation which are structured in this present manner, where it is inappropriate to seek to bind the state in certain regards relative to recovery of debts, any number of areas where it would be not appropriate to have an offences section apply to the state. If I recall, the Honourable Senator would have made reference to persons being incarcerated unnecessarily or unjustly, and now she seems to be suggesting that a public officer acting in an appropriate manner should be possibly facing the criminal offences section, which seems to be she's approbating or reprobating at the same time. But I do not believe that this legislation is out of step with the standing form for these types of legislation as it relates to how the state should be dealt with. And in the circumstances, in answer to my honourable friend, there is no need to amend it.
Senator Goodrich.
Ma'am, I would just repeat myself. In my speech, I said, lock up none or lock up all. And that is my final statement.
The question is that all honourable senators in favour, please say aye. Aye. And those against, please say no. And that is, the question is sections, clauses 26 to 33 do now stand part.
Report.
Madam Chair, I'd like to move that you do not report says on the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
The Deputy President has reported to me the passing of one bill in committee. Senator Cummings.
Mr. President, I'd like to move that this bill now be read a third time.
The question is that this bill be read a third time. Will those honourable senators in favour please say aye? Aye. Those against please say no. I think the ayes have it.
Mr. President, I'd like to move that this bill do now pass and be cited as the Protection of Wages Act 2026.
The question is that this bill do now pass and be cited as the Protection of Wages Act 2026. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 3, sir. Order number 3, in the name of the Honourable Leader of the Senate, to move the second reading of the Beneficial Ownership, Transparency and Register Bill 2026.
Senator, the Honourable Lisa Cummings.
Thank you very much, Mr. President. This bill is before us to deal with a number of critical issues. I remember, Mr. President, being in this chamber on a previous occasion and raising concerns around the timelines for reporting, the capacity for small agencies within government to do that reporting. I remember being in this chamber on more than one occasion and recapping the concerns that this piece of legislation and other pieces of legislation under what we would have called the company suite of legislation and the international business suite of legislation would have resulted in some concerns. I remember also, Mr. President, having an occasion in this chamber to speak about the challenges on one particular occasion several years ago where we were on the eve of having a blacklisting event. Now, we had to navigate those issues, and we have seen Barbados subsequently having been removed from the blacklist for Spain, us being able to do business with Spain. We have seen Barbados having been removed from the gray and the blacklist for the Financial Action Task Force, and I spell that out now because I will use going forward the FATF acronym going forward. We've seen also the challenges of Barbados being removed from the blacklist for the Anti-Money Laundering Task Force and the work of the AML, which I think you, Mr. President, will be very familiar with as part of the AML Task Force itself and also the Financial Action Task Force. So this is a significant body of work that has come internationally that needs to be navigated at this point in time, specifically as it relates to beneficial ownership. When we were navigating at that time, Mr. President, the question of how we would meet the obligations under our Mutual Legal Assistance Treaty and reporting to the OECD, the Organization for Economic Cooperation and Development, we had a number of issues. In the dead of the night, and I've spoken about this when I was the minister at the time, in the dead of the night, I shared in this chamber how we had to call many of the, what I will describe as the CTSPs, Corporate Trust Service Providers, to get information on the businesses that they represented so that we could populate the register, share that information with the Barbados Revenue Authority. The Barbados Revenue Authority in law was the competent authority to report that under the treaty, and they would then ensure that Barbados was in compliance with our international obligations. That is a framework that we historically have had to navigate ourselves around. Now, why is that important, and why do I start there on this legislation titled the Beneficial Owner legislation? For anyone who does not operate in this space, they may think that we're doing something completely new. They may think that, you know, why are we having another piece of brand new legislation and what's the point of that? But here's what we've always done. There has been an ongoing process from time immemorial for us to collect beneficial ownership information. This is nothing new. What we are, however, doing is bringing efficiency and coherence to the way in which that information is collected. And I'll give you a couple of examples. In this chamber, I was still the minister at the time, but I brought the legislation to repeal and to not replace the Economic Substance Act. We repealed the Economic Substance Act at the time, and under the Economic Substance Act, the beneficial ownership information was indirectly required under the economic substance regime. Under that economic substance regime, we were required to provide a number of pieces of information. Where an entity failed an economic substance test, and what is an economic substance test? Economic substance test, it says that it differentiates Barbados as a jurisdiction from other jurisdictions where shell companies, front companies, set up operations, but do not necessarily have any operations happening in the jurisdiction. That's not Barbados. There has to be economic substance, and that sounds exactly how it is in practice. Where an entity was classified as a high-risk intellectual property entity, or where they claimed tax residents outside of Barbados. In those circumstances, we needed to be able to have information exchange between the competent authority of the jurisdiction of the holding company, the jurisdiction of the ultimate parent, or the jurisdiction of the ultimate holding company. And really, it is a complex series of structures that we were digging into the weeds with as we described what was described as economic substance. You also saw me as the minister at the time bringing amendments to the foreign currency permits regime. That legislation we also amended. That legislation, when amended, looked at the inclusion of 2 additional elements, shipping and insurance, as they were at the time. And under the existing foreign currency permit regime, beneficial ownership information is already collected. It's already there as part of the application process, and the applicants are required to provide a number of pieces of information. Details of, you hear this, ultimate beneficial owners, ownership structures, supporting identification and verification documentation, and it also helps to identify a couple of important things. Sanctioned individuals, persons associated with criminal activity, politically exposed persons presenting elevated risk, and persons subject to regulatory concerns. So this is already being collected under the existing foreign currency permits regime. The third piece of existing legislation, which is already collecting this type of information, but in a separate format, is under the prudential regulation and licensing requirements. This information is already collected particularly by prudential and financial sector regulators as part of their operations for licensing, authorization, approval, and their overall supervisory functions. So the Central Bank of Barbados, the Financial Services Commission, and other sectoral regulators may require beneficial ownership information in connection with a number of things: license applications, acquisitions or significant shareholdings, changes in ownership or control, ongoing supervisory reviews, fit and proper assessments, and of course, enforcement and compliance activities. So those are standing pieces of legislation already in force under which beneficial ownership information is being collected. So no new information being collected, already there. The mechanism by which we collect the information is now what is changing. But in addition to the legislative frameworks, there are already domestic competent authorities. And I just mentioned a few of those competent authorities. The central bank is one of those competent authorities for the categories that they regulate. The Financial Services Commission is another competent authority for the entities that they regulate. And I did mention before the Barbados Revenue Authority as a competent authority for the entities that they regulate, for the purposes that they regulate. So they collect this information to either share with their international partners under treaties to which Barbados is signatory, or alternately, you may have cases that may arise where there are criminal investigations underway. Money laundering investigations may be underway. Terrorist financing investigations may be underway. There may be regulatory examinations, sanctions-related matters, and other law enforcement activities for which there is a competent authority. And this is where the Financial Intelligence Unit comes into play, where they are then playing an investigative role in any of the categories that I have just listed for the purpose of being able to collect what? Beneficial ownership information. And that's for the purpose of supporting intelligence gathering and investigations. I mentioned earlier AML, anti-money laundering provisions. That is also routinely covered in terms of the corporate trust service providers, the CTSPs. The CTSPs, to be clear, do not work on behalf of small people like me, and maybe not Mr. President, but small service providers. Small businesses typically do not engage with or need corporate trust service providers. That's usually for larger companies. You typically would have CTSPs, many of them may represent, and Senator Niles would know, some of them may represent 100 companies. And when they come in to do business on behalf of those entities, they're representing a large group of global businesses, usually over a threshold. I'll come to that in a minute. So I just wanted to be able to start to unpack that for the benefit of all the persons following. So what is the legislation here going to do, given the fact that you're already collecting this information? What is the legislation here to do, given the fact that all these different agencies are already collecting the information? It brings a streamlined approach by allowing what used to be the International Business Unit as the compliance unit, now being called BCOM. And this was one of the last pieces of last papers that I had taken to cabinet before the election and before I transitioned. So it's something that I'm very familiar with as a result. When we took this paper up, we had taken the time at that time to go through what used to be described as the International Business Unit. And the International Business Unit, which we had renamed the Business Unit, had been split into two divisions. One had come over to the Tax Policy Unit in the Ministry of Finance because we were framing tax policy, and that was really a function of a Ministry of Finance and not a Ministry of Business. And then on the other hand, you needed to be able to repurpose the skills that were in what used to be called the IBU to serve a compliance function. And so that unit is now going to become what we call BCOM, the Business Compliance Unit. And they will take responsibility for collating in a single place under this one piece of legislation and using the mechanism established by the legislation for a beneficial ownership register, where all of the information will be collected in a single place with one single submission by businesses. That's what the legislation actually sets out to do, to simplify and to create coherence around the collection of business data for all businesses under the beneficial ownership regime. That's really what we are looking at this point in time. And so I want now to get into two things that the legislation also is meant to do. It is meant to collect the information, which I've said. It is meant to maintain it in a register. I've said that. But it is also meant to verify the information, and that's where BCOM is also going to be taking a role. Verifying that that which is collected is which is also accurate. What is also accurate? What correlates with the documentation that has been submitted? And I know that even if you go from the nursery school classroom all the way up to a corporate trust service provider, all information when you submit it is always checked over by somebody. It's verified as accurate. If it is not accurate, it's sent back for corrections, and then you maintain the information. That's really what the verification, in very simple terms, is meant to do. And so the beneficial ownership register will simply build on the existing framework that I've taken the time to outline and create a central, single repository of information that is already being required by the government and by all of our international partners, by companies. So rather than replacing an obligation to maintain beneficial ownership records, the register will simply modernize in the way that I have described and strengthen the regime by doing a few things. It will reduce the manual collection of this information. We've built so many platforms collecting the information using spreadsheets, figuring out how to transition those spreadsheets from the International Business Unit over to the BRA, making sure that what is transferred over to the BRA then has to be scrubbed and verified. So you scrubbed and verified it on IBU's side. Then you have to send it to BRA, scrub and verify on the other side. And then you have to have agreements that allow the BRA to receive information from IBU, because you can't share information across government agencies without permission. So you've had to go through all kinds of hoops to be able to maintain, to access, to maintain, and to verify the information that I am describing. So manualization of the collection is being phased out, and you now will have a digital registry. The second thing is to ensure accuracy. There is a real constraint, and I know this well, when inaccurate information is submitted to international partners or is reported on under our treaty obligations. It means that you have to either, one, have an extension of the timeline, or mercifully, if you're early, to make amendments, or alternately, you could find yourself being penalized for doing the wrong thing when you haven't intended to do the wrong thing. It's just that the information is incorrect. It also is meant to allow for more efficient supervision, and of course, as I mentioned, this is a compliance measure, and to allow for compliance monitoring, to allow more rapid access by the various competent authorities. As we go through beneficial ownership information, as you would have heard from my presentation as I went through it, There's no single competent authority for all the different types of information that you're collecting. There are multiple competent authorities. So you want to be able to have them in a single place to make for ease of access. And then finally, Barbados does not live in a vacuum. When we talk about global business, especially business over a certain threshold, you know you need to make sure that you are compliant with international obligations. When we celebrate coming off of blacklist or gray list, it's for a really important reason. And it is this. When I spoke about it in previous pieces of legislation, in 2022, I think it was, when the tourism sector, as a result of COVID, was still in recovery, it was the global business community that through corporation taxes that kept the economy afloat. In every successive year, there was one year, not this year or the year before, but the one before that, where we collected around $470 million in corporation taxes, and the following year, we collected about $1 billion in corporation taxes, giving the government the wherewithal to give Barbadians back a cash return, but also to meet the requirements of Barbadian citizens. We spoke earlier, and we talk all the time, about the balance between rights and obligations. In our households, we talk about the balance between rights and obligations. In our household, we talk about balancing what you can and what you cannot do. We as a society, we can't want, and we can't ask for the government to do different things while still frowning on regimes like this that help to create a safe space for global business to exist without penalty. And when I say without penalty, Mr. President, as you well know, there are certain categories. Barbados is, I believe, number 8 in the world in captive insurance domiciling, number 8 or number 7 in the world, somewhere around those lines. And other jurisdictions in the region are competing against Barbados. When we badmouth Barbados, when we bad-talk Barbados, and we say Barbados is the worst place in the world to do this and the worst place in the world to do that, we're not just talking to the local audience that is around us. We say that in the full audio of everybody else who will be in the sight of the next newspaper that is printed, or will be listening to the next news story that is reported internationally, and that sends a message about your country. That sends a message about your country as a viable place to do business. And so when we talk about AML, when we talk about Financial Action Task Force, and when we talk about the captive insurance industry, one of the reasons why we have always been concerned about gray and blacklist for Barbados is that unless Barbados is removed from those gray or black lists, those companies have to pick up and move domicile. Those companies have to pick up and go elsewhere. And you know what? Sometimes they do. For all kinds of reasons, sometimes companies will shift and go to a different jurisdiction. And that's okay, but we have to preserve the reputation of the jurisdiction. 1, by action. 2, by continuous transformation, because I've said this before as well. 30 years of doing things one way will not disappear by magic in 2 minutes or in a year or even 2. It doesn't happen that way in the private sector. It ain't gonna happen that way in the public sector. So things will take time to change. And so equally, they will also be impacted by our words about our country. And when we think that we're scoring cheap political points or scoring one-upmanship, but in actual fact, you are bad-mouthing your country to the very people and to the very international community that you have to depend on to pay corporation taxes that help to fix roads, that help to put goods in our stores, that help to be able to put medicines in our hospitals. Those are practical considerations that I'm telling you that unless you are the government with an obligation to deliver on them, it may seem like a joke. And you can talk about them as though it's a dream thing, and you can talk about them in abstract because you don't have an obligation to actually deliver on them, but we do. We have an obligation to deliver on them, so we have to always be responsible about what we say about our country. We do that with the full knowledge that everything is not perfect, but vomiting all over your country adds no value to you. I promise you. However, here we are with this legislation that does attempt to tell the story of a jurisdiction that is taking seriously not just what is required of us domestically, but it is taking into account all of the various nuances. And this is where I want us to get into a little bit of the weeds here for a minute. So I did, as I was preparing for the presentation, I want to go through the legislation in its sections, but I also want to address, as I do so, some of the things, or at least one of the things that I heard in the media, which is grossly erroneous, and I want to correct it for the record here today. In part one of the legislation, it speaks about the preliminary interpretation provisions, and so we see that there, sections 1 through 5, clauses 1 through 5. Then in part two, you actually have the provisions for what I've described as the beneficial ownership register. So you have the beneficial ownership unit, you have the business compliance team, which I have just outlined already. You have confidentiality, because confidentiality is important. And when I say confidentiality, I want to make this point here. There is a conversation around whether this is going to be available for public viewing. I don't know what information would be of value to me to know Senator Walters' business information. No, I don't know. There's no value besides me being malicious. I want him to be in his business. No, gypsy. So there is a provision in this legislation in part 2 under the beneficial ownership register, where it is a private register. It is a private register. It is not for John Public to come and say, I want to see what he got, or I want to see who owned that day. That's not what this is for. There must be, for the purposes of global business, a certain level of confidentiality to business generally. That's what is expected, and that is what is the standard globally. However, I used the term before, competent authority, on purpose. There are any number of competent authorities who legitimately and within the provisions of the law can request access or can access the register. That's what they're there for. They're there whether you are the BRA, if you are the Financial Services Unit, if you are the Financial Services Commission, if you are the Financial Intelligence Unit, if you are the Central Bank. Any of those entities are legitimate entities that have an investigative and a compliance role. Ms. Braffett on the Pike Corner bus is not a compliance officer. However, those agencies are, and they have the ability to see the register by law. That is provided for in the legislation here. At part 3, I spoke earlier about, I did speak about access by competent authority. I did speak about that. In clause 10, cooperation with a foreign competent authority. I already went through that as well at clause 11. And then electronic filing, by definition, here is the submission. Now I want for a moment to just point out the electronic filing. One of the things that's so important about this legislation that I'm happiest about is that it removes the need, and I will spend a moment on smaller businesses later, but it removes the need, it takes away the need for us to file those problematic and troublesome annual returns that I know a lot of smaller businesses struggled with. So once you have brought up to speed your obligations under the beneficial ownership register, you have filed your beneficial ownership information, your obligation on an annual basis is to simply verify that nothing has changed. You've not had a change of directors, none of those things, but it removes the need to submit annual returns. That is a major transformation under this legislation, because I know a lot of small businesses really had a difficult time with this. So, and why did they have a difficult time with this? You know, when you think about making things easier for people, you have to consider what it means, right? So when you go through the process of registering a company, a lot of people register companies for different reasons. And you go and you register a company. Once upon a time, you used to have a lawyer to guide you through. That's not necessary. That hasn't been necessary for a long time. So it meant that people went and set up companies. Some people registered 3 or 4 different companies and 4 and 5 different company names, but no one told them at the time that they needed to file annual returns for each of those companies. And so when those companies find themselves in year 2 of operations, worse yet in year 3, one, they did not file annual returns after the first year. Then, having not filed those annual returns, they are levied a penalty of $10 a day up to a cap of $3,000 annually. And if you have never filed annual returns, like your local doctor, your local consultant, your local whoever, and you have multiple years that you have never filed, 10 years, 20 years, all of a sudden, you find yourself in the crosshairs of compliance authorities. But why? This is, again, I situated this bill on purpose within a domestic and a global context. We do not exist in a vacuum. There are things that we may not see ourselves that compliance authorities will see. I know what it is to be a Minister of Commerce. I have to sit with legal authorities, judicial authorities, because they're involved in investigations, whether it be on terrorist financing, whether it be on money laundering. I know what it looks like. I would not have known that if I didn't sit in those chairs, right? So when there is a requirement, especially under certain agencies, for the levying of penalties as a result of non-compliance, those are the things that are monitored by international organizations to whom we are reporting under multilateral conventions to which we have signed, and so enforcement of those things is important. And so under this legislation, once you have now signed up for your beneficial ownership information and it's electronic, no longer manual, it removes that burdensome annual returns process. Now, in Part 3, clauses 13 through 18, it talks about reasonable steps I talked earlier about this verification process, the reasonable steps to identify the beneficial owners. Now, when we talk about beneficial owners, it doesn't mean that Senator Walters is registered in Barbados as the owner of ICE Productions. It doesn't mean that. It may simply mean that Senator Walters, in this instance, is a front man for Senator King, who actually is the real owner of the company. And we ain't get to Senator Archer yet. And then Senator Archer is the ultimate beneficial owner. But the person who's the front for that company is Senator Walters. But between Senator Walters and Senator King, and then ultimately Senator Archer, you have to be able to figure out who is the ultimate beneficial owner. And that's what happens in a lot of companies. You have some companies that may register under one name, one person, one director, but then they really have a parent company or a holding company. This legislation delves into the weeds to figure out who really is the beneficial owner. It establishes a regime also where there are nominees, and you will find that in actually in Part 2 under the beneficial ownership in register, as well as in Part 3, where if you are what is described as a nominee, meaning that you are acting on behalf of someone else as a director, then you definitely have to provide that beneficial ownership information. So you have to undertake the steps to identify who those beneficial owners are. You have to create the difference between Senator Walters and Senator Archer, with Senator King in between. And here's why. Globally, and yes, locally, you have Barbadians who all the time tell us about all different kinds of things. Let me talk about it in real terms in this Senate Tenant chamber tonight. You have Barbadians who will say to you, but the small boy on the street ain't really the person who could ever be behind so and so and so activity. There gotta be some big boys that you gotta find. How do you get to them? That's where the work of the Financial Intelligence Unit comes in. That's where the identification of who is the real owner of companies who are being used as masks to front for illegal activity can be identified. This is one of the pieces of legislation in the arsenal of going after not just the small boy, but the big boys who are behind the real money of terrorist financing or illicit activity. This captures that as well. And so I know that sometimes when we talk about crime, when we talk about criminal activity, people always don't necessarily make the connection between very technical pieces of legislation like this and how it actually affects the things that the public has been calling for, but we are obligated to do internationally. This is also about finding the sources of terrorist financing and illicit proceeds of financing. Under Part 4, where you have verification, I believe I've spoken about that already, but what I draw attention to at this point is Clause 22, where it talks about incomplete, inconsistent, or suspicious filings. If it looks funny, if it looks suspicious, then there is a need to do further investigations, and that's the role of BCOM. Under Part 5, enforcement measures, administrative penalties, striking off, and deregistration. Now, deregistration and striking off is a result of the inability to verify under the various pieces of legislation that the company is who they say they are. When it was economic substance, you could be struck off. When it was for annual returns under the Companies Act, you could be struck off. And now for beneficial ownership legislation, and it is not verified, you can also be struck off. And that becomes complicated because if you are struck off the company's register, things like simple things like doing banking and being able to make financial transactions are impaired because then you are struck off of the register. You do know how many people, Mr. President, would have called me when I was Minister of Commerce to say, I can't believe that I get struck off the register and all of a sudden I don't know what happened. But the reality of it is that in practice, you would have had to have received multiple notices and ignored them for an extended period of time to have found yourself in a position of being struck off of the register. This legislation, for the purposes of identification and verification of beneficial ownership, allows also for striking off. Under Part 6, it talks about representation, rectification, and appeals, the principles of natural justice that we speak about in every piece of legislation, the right to be heard, the right to appeal, and the right to an audience. Those things are covered in the legislation here. Part 7 goes on to speak about offenses, guidance, and various regulations, and it makes a distinction between a legal person and a juridical person for obvious reasons. And this is a big part of the role that is being played here. And then finally, we have clauses 34 all the way through. I did speak about that. Legal versus juridical persons being captured. I'm trying to find my notes here, right, because I want to spend my remaining time, Mr. President, speaking about the erroneous information that is being shared in the public domain about the implications of this legislation for small businesses. One of the key things that this legislation set out to do when it was first being developed, and the beauty of government is that it is a continuum. And so while it may have started with me, it has continued ably under Senior Minister, the Honourable Kerry Simmons, and he would have presented in the other place on the legislation. But it covers small businesses on purpose. And I want to get into the beneficial ownership regime as it relates to small businesses. Now, this piece of legislation was deliberately designed so that small businesses are not overburdened. There are 3 ways in which this was done to ensure that this did not become a burden on small businesses. And I know that there are some persons in here who are particularly interested in the small business regime. First, there is a simpler filing route for small businesses. Domestic companies and societies earning less than $1 million a year will file their information through BCOM. I've shared with you what BCOM is. They will review it with you, help to ensure that it is correct before it goes on the register. One of the things that we found a lot of times is that people are not out of compliance because of maliciousness. Sometimes they're out of compliance because they just don't know, and they need to be guided and they need to be assisted into doing the right thing. That's what is being set up here, and there is no requirement under the legislation for large corporate trust service providers that I mentioned before to be used in the instance of the small business community. That is going to be done by BCOM. Secondly, there is a tiered fee structure for businesses of different sizes. I've just mentioned that if you are under $1 million a year, then you have a simpler filing system. There's no reason why a small business should have the same filing process as a company that is earning $500 million in a year, because you have more resources. You have more, when I say resources, I mean that you may have a whole accounts department. A business that is a small business that does not have that kind of institutional capacity doesn't have that kind of wherewithal to do that. And so it's lower fee for smaller businesses. If you file through BCom, the cost is $150. For larger entities, using the corporate trust service provider, you have to pay the corporate trust service provider for sure, but your filing fee is $250. And so the small service provider is not being asked to pay the same thing as the large company. Thirdly, the legislation is also removing the paperwork, and I spoke about that earlier when I talked about the annual returns. Under this bill, companies will no longer have to file the old annual return form. The annual confirmation of ownership information replaces it. So for a lot of businesses, this is not an additional form that you have to fill out on top of all the other things that you have to do, because let's think about it and be honest about the realities of small business in this country. There was a study a few years done, maybe last year, and in 2016 was the one before it done by the Cahill School of Business on the MSME sector in this country. In both of those studies, it found that we were well over 95% of companies in this country as MSMEs, micro, small, and medium-sized enterprises. Many of them were sole proprietorships. So there may be the people who are accustomed making hand soaps, they're making the hand soaps, and they're selling in the front of house. They may get the opportunity to hire one person who may be their salesperson while they still continue making their soaps in the back of house. They don't have accounts departments. They don't have accountants generally on staff. They don't have the wherewithal to do that. And so this legislation recognizes it, and the way in which this government has been attempting to roll out a suite of interventions in support of small businesses, this legislation equally recognizes that there is a differential between small businesses and large businesses, small businesses capacity versus large business capacity, and it accounts for that. For the vast majority of Barbadian businesses, I say this without hesitation as a former minister of business, most Barbadian businesses set out to be compliant with the law. The number of people who call and say, I don't understand so-and-so, you can help me with this, or I just got this letter, can you help me understand what it means? I want to set up a company, but I'm not quite sure what to do. Can you help to guide? If you don't work in government, Mr. President, you don't understand the abyss that can be government when you send something into one department. But even if you work in government, it's still the same abyss, Mr. President. So what then of a small person whose livelihood is pegged to their ability to earn, but it's just them as a sole proprietor in a small business? It's a real issue, and the legislation and every piece of legislation that this government brings takes into account those differentiations. So I wanted to be able to give the assurance that despite some of the reports that I have seen in the media, this legislation does not add any new obligations to small businesses. That is not accurate. Far from, it attempts to simplify them. So then, Mr. President, I've spoken about the issues of nominees. I'm just going over my notes just to make sure. I've spoken about the private register and ensuring that we balance transparency with safety and privacy. There are things, Mr. President, that we in Barbados take for granted. I remember when I was a young Foreign Service officer, Senior Minister St. Clair, a young Foreign Service officer at the time, and I remember going to a country and being surrounded in a vehicle with the other ministers by masked security officials, guys hanging out the side of the vehicle with long assault weapons, tear gas on the streets, big tanks that look like they belong somewhere in the Middle East, in the middle of a war that is actively underway. We live in a country where we don't see that, and so we take a lot for granted. So we don't realize that keeping a private register, especially when you are a jurisdiction of global business with major companies headquartered here, that keeping that information private protects people and their families sometimes from things like kidnapping and ransom. Those are real things that happen in parts of the world that may not happen here. And so we have to uphold the standard that is global in order to genuinely, equally be a global jurisdiction for business. Publishing the information of a person's family business or a family trust as an indication of their wealth can expose families to kidnapping and ransom and threat. And so those are some of the things that allow us to meet our international standards here in Barbados and not allowing the whole world to see what everyone has to do while maintaining and keeping Barbados a safe and attractive place to do business. Mr. Speaker, let me sum this up for the benefit of those listening as I close. We want to make sure that Barbados is a jurisdiction of choice to do business because it is safe to do so. We want to make sure that we have met all of our international obligations to all of the international bodies that we have to meet obligations to because we've signed on. We want to make sure that Barbados cannot be used as a jurisdiction to hide dirty money. It means that our banks, our businesses, and our citizens can keep access to our international financial system, which is required for our economy without being placed in peril because we have not put these kinds of guardrails in place. It means also that for small businesses, they have the protections and the tiered system that I have outlined, allowing them to be able to continue being legitimate business owners without having the onerous burden placed on them. And it means that when our international partners come to Barbados, whether this year, the next year, or any other year, that Barbados is seen as that jurisdiction that continues to modernize, upgrade, reform, transform our international financial system, our terrorist financing legislation, our protection of assets regime, but it does so in a way that is transparent, open, and in accordance with international standards. That, Mr. President, is what this beneficial ownership bill is about. That is what the register is about, and that is what this government, as a commitment to a jurisdiction that supports and promotes global business, is also about. And with these few words, Mr. President, I beg to move that this bill is read a second time.
Thank you, Senator Cummins. Any speakers? Senator Goodrich.
Yes, sir. Thank you so much. I rise to discuss the beneficial ownership, transparency, and register bill 2026 this evening. I won't be too long at all because I know it's late in the evening and I'm trying to conserve my energy too. I recognize that the leader of government business, Minister Cummins, she made some very critical points there as she said that, there would be a private register. That is a key point. And we are not a country that will want to see money laundering happening so prevalent. We know that it exists and where we could use the legislation to place barriers, it is important and essential to do so. And of course, as you mentioned, the circumstances that could occur with kidnapping and so on, we say no to that. We don't want those type of issues occurring in Barbados. Sir, I know that whenever people hear of bills such as this, they already know that a register is there and will be created and a new governmental unit. And whenever people's personal information is being handled by any unit, they query why, and they want to know also that their information will not be leaked to the public in no form or fashion. I know that cybersecurity will be a major concern in the minds of our people. Because many of our citizens will ask, well, what's the purpose of this bill? Could it not have been updated in the Companies Act, to include the information of the beneficial owners of a company? So some people might ask, what's the purpose of setting up this separate unit? Because of course, more staff will be needed. We're going to study, a new office will be created, more funds.
Mr. President, I rise on a point of order.
Yeah, what's the point of order?
I just wanted to guide the Honourable Senator that there is no new staff being created. We are repurposing existing staff, as I said during my presentation, from the existing international business unit, and they are being applied to a compliance role. They already have offices in the Baobab Towers. They're already set up. It is simply a transition of repurposing of existing staff.
Please continue, Senator.
Okay, thank you for that update. I do hope that no one would think then that we are duplicating offices. Those are things that people do say on the road that I have heard, but I will continue by stating that Section 8 of the bill establishes an electronic beneficial ownership register which will have detailed personal information which is required to be submitted. And we have already experienced data breaches in this country, unfortunately, in the governmental department, sir. So people will want to know why not secure the existing government databases first before putting even more personal information out there. Because as I told you, sir, people just want to know that their information is secured. And this is one that will be electronic, it is digital, and when this information goes online, people don't want to know that there's another data breach faced by government. So government has to ensure that it has all
Mr. President, I
necessary...
rise again on a point of order.
Yes, Senator, come in.
I'm deliberately trying to make sure that I do not allow my honourable colleague to run too far down the wicket with inaccurate information. This is information, as I said before, already collected by the government under multiple pieces of legislation. It is already collected electronically. This is not new. It is simply being put into a single place, as is the case. It could right now be accessed under any of the other agencies dispersed across government. So I don't want that there is any misunderstanding based on what the Honourable Senator is saying at this point.
Continue, Senator Goodrich.
Thank you. In this age, sir, of identity theft, cyber fraud, and online scams, these databases will be attractive, for hackers and targets. We can't get away from it because there are times where people would experience, having to face a situation where their passport could be stolen, driver's license, tax identification number, or home address, which could be used to commit financial fraud for years. And this is a great concern, sir. So the leader of government business, they say that these things already existed, but we want to know, since there were government breaches previously, that the information that is there now will certainly be protected from leakages, that people don't have to face this identity theft or have to deal with scammers and so on. I know that these are things that no matter how you try, other countries have faced them and they have some of the greatest systems in the world, but people just want to sleep good at night knowing, look, the government are doing their best to ensure that this personal information is greatly protected. Now, I want to look to the penalties for leaking sensitive information. Because when your information is out there, and it gets out to the public, somehow gets in hands that can cause mischief. So I see it as a serious offense, and I know that Section 9 makes provision for data breaches, releasing individuals' personal information under the Data Protection Act makes the offender liable to a fine of $500,000. So I see that there are many times in that act where it's a $500,000 fine and or 3 years imprisonment. However, I recognize now we are passing this legislation, and It has a lesser fine by far because it only attracts a $40,000 fine and or 1 year imprisonment. So, sir, the situation is the same because my question would be, why should identical confidential information receive a much lower level of protection simply because it is stored under a different act? That's my curiosity right there. So I would really recommend that the penalties contained in the Data Protection Act be maintained in this legislation if it is passed. Because all two are dealing with confidential information being leaked. And it's the same thing, it's a serious matter. So why have a lesser fine? Why 40,000? So people can be rest assured that, look, if we look at this fine, or 1 year imprisonment, sir, that is only one Christmas miss. That is not really a deterrent. One Christmas miss in jail. So some people might look at it and say, well, one Christmas, I don't miss that. People think funny out there, you know, sir. So basically, those fines need to be strengthened. And I could go on to say that $40,000 is not hard to save up. But in comparison, $500,000 as a fine, let me tell you, many people will not be able to get $500,000, so they will keep out of trouble and do the right thing. So, sir, I want to go forward and state now. I noticed in the bill, in section 11.2, it refers to treaties and international cooperation frameworks that will require Barbados to share the personal data of companies operating here. So it would be useful if we know about those treaties in advance and those cooperation frameworks. I would love them to be made available for review so that we know exactly what commitments Barbados has made and with whom this information may ultimately be shared. So I was curious when I saw that section. I was like, what treaties or cooperation frameworks are they talking about? I would love to review that. That would be a pleasure of mine. So just, you know, when we're dealing with that international data sharing, we want to know.
Mr. President, I rise on a point of elucidation.
You haven't spoken. You cannot elucidate on anything you haven't spoken. You can only elucidate on what you've spoken about. You haven't spoken in this debate as yet. You haven't spoken in this debate as yet, so that you can't make a point of elucidation.
Sir, can I rise on a point of order?
You can raise on what you want. It's a question of whether it's valid. What is the point of order?
Sir, I think that the honourable senator is misleading the House, and I just want to state that it is not custom, it's not practice to legislate treaties. It is well known that those arrangements change from time to time, and therefore, it will be considerably risky to try to do such when at any point of time those situations can change. So I just wanted to make that point.
Thank you for that point of order. Please continue, Senator Givich.
Sir, I just want to thank Senator Slocum, and I don't mind if he raises a point of order of hallucination, because he hallucinated that he was going to win, and he didn't win. So it's okay if he hallucinates. Talk about that. Talk about that. Raise on a point of order, don't hallucinate.
Yes, Senator Slocum.
Mr. President.
Yes.
Mr. President.
Order, please, order. I want to hear Senator Slocum.
Mr. President, I rise on a point of order. The honourable senator is now misquoting me. I am very well au fait with the English language, and I am not hallucinating. And I use the word hallucinate. I am so bewildered at this point. So I don't know if she's hallucinated, sir, the honourable senator, but I'm not hallucinating at all.
And I heard you very clearly, Senator Slocum. You did say in your very clear voice that you rose on the point of elucidation. It's just that from the rules point of view, I corrected you, and you went on a point of order, but it was elucidation. There's no hallucination allowed in this house. Yes, indeed. Senator Goodrich, please continue.
Thank you, sir.
Order, please, order.
So, sir, my main point was make everything transparent for us. So, what I would say was important because the bill requires the information to exist in digital form, right? Once digital information exists on a device that is connected to the internet, it will become a potential target for cyber criminals. It happens. Cyber criminals cannot wait to know that there exists a platform that they can hack. And also, history has shown that even highly classified information can be leaked by insiders. When I did my research, sir, I looked at a name of a man called Edward Snowden. And Edward Snowden was a man that leaked all the private information to journalists. So I reiterate my point that these are things that can happen with some of the world's largest intelligence agencies. So it is reasonable to ask how secure will our systems be here in Barbados. Because the government has already admitted that its computer networks at the BRA and the Barbados Statistical Services were hacked and data was stolen. So this is where you see that I'm stuck on this point, because our governmental systems here were already hacked and information was stolen. The information reportedly included, it was property tax records and other personal information belonging to Barbadians. Not Russians, not Asians. Information belonging to Barbadians, where more than 200 gigabytes of stolen data was reportedly offered for sale on the internet, sir. And we don't want this to reoccur. So there is also the broader issue of trust in the technology itself, sir. And we need to know that government departments will be properly equipped. And we know that sometimes even government departments have computers, sir, that will be given to them, donated from foreign governments. And some cybersecurity experts have warned, when they did my research, they warned internationally about the possibility of hidden hardware or software vulnerabilities in imported technology. So these hidden softwares is also a problem, because whether or not that concern exists, in any particular case, Barbados should regularly audit critical government systems. I believe that auditing is quite important. It is something that we have to get in the practice of making sure that it is on point.
Keep going.
Yes, sir? So with the rapid advancement of AI, artificial intelligence, sir, digital information can now be analyzed, altered, or manipulated much more easily than ever before. And we may not see it now, but those who use it will know what I'm saying. When you have AI, you can manipulate that information, important information on a computer. You could do all kinds of things with it with this use of AI. AI currently can manipulate a signed paper record sitting securely in a file cabinet. This is life. These are things that happen when you have AI. That's why some places now are using it more than ever. But the truth is, it has its pros and it has its cons. It can manipulate the information, and then when you have all of this information in a system digitally, you then have to ensure that all this information is monitored properly. Because when you have AI and AI changes this and that, and you don't have any paper records, you're looking for problems. So I believe that we should continue embracing, yes, the digital systems, because I know that we are in modern times where appropriate though. But however, where records carry significant legal or financial consequences, sir, there is value in maintaining, as I said, certified paper records as an audit trail against which the digital records can periodically be verified. So if we have a bit of paper trail, as I said, with important information, that is necessary because when AI gets in the hands of the wrong people and they use it and manipulate information, you then can audit the papers in your hand. You can then check back and see from the paper trail what people actually handed in, all the information that they handed in, instead of just relying on everything to be electronic. So I recommend that the bill would be amended to allow persons to provide both the paper and the digital records for those purposes, sir, with the paper copies retained for audit purposes. And that's where my focus is, the audit, the purposes of having a proper audit. We should also undertake regular, independent cybersecurity audits of government systems so we understand our true level of exposure before expanding the amount of sensitive information we collect. And this is very important. Right now, I'm not studying if I'm a Friends of Democracy, which I am, or if I, every people saying if you belong to a different party, no. My focus here is right now, as speaking as the leader of FOD, is to focus right now on the betterment of this country. I didn't make it clear. Since the leader of government business was wondering where it was going with that, I made it clear. I am here to assist with this bill and make the requisite recommendations so that, I can speak to the fears of every Barbadian who will be wondering, but will the systems be leaked again, and what will happen to my information? So, sir, we've talked about compliance costs for businesses. The Bible says money is the answer for all things. So when it comes to money, businesses know that from the moment that they have to comply, that sometimes it comes with a cost. And Section 14 requires businesses themselves to establish and maintain digital records. The government has not yet demonstrated to me really that it, can really protect the highly sensitive information since those departments had the issues that I mentioned. But we are requiring every company in Barbados to maintain additional digital records that could expose them to similar cyber risk. So if government, with all the public resources available to it, continue to struggle against cyber attacks, how are the small businesses expected to purchase expensive cybersecurity software? They have to get secure servers, encrypted storage, staff training, and ongoing technical support. All of this could come with compliance. A family who owns a shop employing 5 or 6 people, his business may not be making all of that money to afford certain softwares that will be necessary. But if you are in modern times, you have to be up to the time.
Mr. President, I rise on a point of order. I really hesitated to interrupt Senator Goodrich's most rambling presentation yet, but I genuinely cannot allow what was just said to pass. What would small businesses be doing acquiring expensive servers and software? There is a clear requirement on the service, in this case the government, to invest in whatever cyber technology, whatever servers, as is the case with every other piece of registration information required across government. I am not aware that, Mr. President, the shop at the corner of Marhill Street had to buy software or servers to service their TAMIS submissions. I'm not aware that that ever had to be done. So how would that be introduced into the debate today? Mr. President, the Honourable Senator is misleading the House.
Thank you for that clarification, Senator Cummins. Senator Goodrich, please proceed.
I don't know who's rambling because she waited to the end to say what
there's no
she
she
read
in here. The only honourable senators here.
Minister only said that it was misleading the House at the end and not at the beginning. So what we want for one senator, we expect that we have for all. Sir, I made my point. So thank you, sir. Section 15 requires.
Order, honourable senators. Order. I'm listening very carefully to Senator Goodrich. Please allow me to do so.
Thank you, sir. Section 15 requires every company to file annually with this new government department called the Beneficial Ownership Register. No, I don't know if that is an admission of any inefficiency, sir, but the information required by the Beneficial Ownership Register should already exist, as Ms. Cummings said, or could easily be collected through corporate affairs. If additional information is needed, I'm wondering, why not just simply request it from corporate affairs?
Mr. President.
And what do you raise, Senator
I raise
Cummins?
a point of order. To my certain knowledge, the Corporate Affairs and Intellectual Property Office has not existed for the last 3 years. There is an entity that was created, and I happen to know it well, called Business Barbados, which subsumed the Corporate Affairs and Intellectual Property Office. And I believe that in this chamber and in the other place, when we do our research and preparations for debates like this, we come across important information where the Registry for Corporate Affairs was being transitioned over the last 2 years to a new registry. But in any event, I expect that I'm not an attorney, Mr. President, and you will have to forgive me, but I believe that compliance and operations procedures are meant to have a Chinese wall between them, and they're not meant to cross over. But I know that all persons who are legally trained would know that as well. So I'm not attempting to correct the honourable member, but compliance and operations must always be separate.
Please continue, Senator Goodrich.
All right, thank you, Minister. I will continue. Thank you, Mr. President. So a concern that I have, sir, is that third party is concerned with the third party examiners. Now, the examination provisions in Section 21 to me create an unfair burden on businesses in Barbados. I tell you what, the Beneficial Ownership Unit may examine the books of any company and may hire third parties to conduct those examinations, with the company paying all associated costs. There's nothing preventing that third party, sir, from later working for one of the company's competitors. The possibility is there. These things do happen. And even where no confidential information is deliberately disclosed, sir, the appearance of a conflict of interest could undermine confidence in the entire system. So imagine a company that has developed a new manufacturing process, a pricing strategy, or a confidential customer database. Those commercial secrets may be among its most valuable assets. Stronger safeguards, sir, should therefore be included to prevent conflicts of interest and protect commercially sensitive information.
Mr. President, I rise on a point of order.
Yes, Senator Cummins.
Mr. President, I went through this legislation in Part 8, and the information that is captured and identified under Part 8, clauses 1, 2, 3, all the way through, Mr. President, to 9, do not provide for any provision of commercially sensitive data, any sales strategies, or anything proprietary to the business. This is limited to identification. So I would not wish the Honourable Senator at all to go down the line of speaking about trading in trade secrets or commercially sensitive information, because there's nothing in the legally structured information required to be provided under the BO register that would call for that information to be submitted to anyone.
Sir, I mentioned all that as I was talking about conflict of interest and the fact that government may hire third parties to conduct examinations.
So just for clarity,
And it's okay, you know, sir.
I'm just trying to understand. You're talking about third-party inspections. In what section is that? Are you referencing there, please?
I was talking about section 21, sir.
Yes, I'm looking at it, but I'm not seeing anything here about third-party inspections. It mentions the beneficial unit may examine, and all this relates to just verifying the information on legal persons.
I crave the Parliament's indulgence, sir. I'll pull it up. Trying to find my section 21, sir. Right, so we're talking about examination, the beneficial. Sir, I saw that when I was reading this. But anyhow, sir, Saints' time is upon us.
Yes.
I'm not going to bore you with. You know, I don't bore you with coming in here and talking about Miss Pollard's cat and all that and things that is just an overview of the bill, sir. I actually sit down, I go through the bill to bring the information to you.
Yes, I understand, Senator. I'm just trying to get the details.
I will continue in taking in consideration the time that we have. But, because I have to make sure, you see, it's essential sometimes that they send us the exact statute that they're looking at too, because they don't want to know that I download the wrong thing. But I know that I read that section concerning the examination provision in section 21, and we just have to ensure that then we don't have to hire any third parties to conduct those examinations. So that's fine. I'm moving on. Now, I want to look here now at the excessive penalties and the criminalization, because that is another concern of mine. Another concern is that if any company employee conceals information required by this bill, they become liable to a $100,000 fine and 5 years imprisonment. If a company owner, director, or senior official commits the offense or the offense is repeated, the penalty increases to a $200,000 fine and 7 years imprisonment. So all I want to state, sir, is that, let me just state that I was referring to sections 32 to 34. Sir, these are extremely severe consequences. There's an important difference between deliberately concealing ownership to facilitate money laundering and a small business making an administrative mistake, sir. Misunderstanding that a filing requirement or missing deadline is quite different, sir. The law should distinguish between intentional criminal conduct and ordinary compliance failures. Sir, those are my points. I don't mind all the snickering around town. When I state things, I make sense. And I don't need no confirmation from nobody. That's called confidence, sir. When you have confidence in yourself,
you have my undivided attention, Senator.
That's right.
Please ignore any
good.
chatter in the room.
Sir.
Well, Honourable Senators, please allow me to hear Senator Goodrich with clarity. Thank you very much.
So, sir, I've listed all the concerns that I have there with the bill. And one of my major concerns, as I said, was the possibility of data being leaked on the internet. And also, one of my other major concerns was how artificial intelligence could be used then to manipulate digital information. So I do hope that the Honourable Senate would enlighten me by, adhering to some of those recommendations that I propose, because even though we are in modern times, it is essential that we do keep a paper trail for auditing purposes. And those are key points that we could use to actually help every Barbadian in this country. So, sir, thank you. That's my respectful submission.
Thank you very much, Senator Goodrich. Senator Maladou.
Thank you, sir. I will try to keep my comments brief as usual. First of all, dealing with the Act itself, sir, I want to say, as far as I can understand, and speaking to service providers in this and having practiced a little bit in this area, this is an act that is needed. It is well thought through, and it has my full support. However, I want to turn my attention to two matters. The first one is the implementation of this. I have grave concerns about our ability to do this. And I realize that we have a responsibility to do it. I've heard the Senator, and we have exchanged on this many times, the need to stay off of these grey lists, black lists, and everyone else's lists by having a robust set of local legislation that meets the standards that we need to have in the international business community that we wish to play in. But simply passing the laws does not tick the box. It has to be implemented robustly, and we have a real problem here. 3 years ago, as the Senator mentioned, we changed from CAIPO to Business Barbados. And at that time, we felt strongly, the government assured us that this was going to be a solution to the myriad of problems that we had with the implementation, the delays, etc. Unfortunately, a significant progress has not been made in that regard. So let me just take two examples out of what this legislation requires, and let's talk about what the problem with implementation of this is going to be. There is a 14-day deadline in this legislation to report a change of beneficial ownership. I would have expected to see, therefore, that there would simply be a similar timeline in the law imposed on the state to actually process these change of ownership forms, ultimate beneficial ownership forms. The reality is today that that requirement exists in other parts of the law. There is, for example, let's take the annual returns that have to be filed under the Companies Act 15A, which is being changed under this, as well as the Domestic Companies Act, I think is 15A. 343 is the External Companies Act. Those returns that have to be filed today are taking years to be processed, years. At the time we changed from CIPO to Business Barbados, sir, you might remember that I spoke on this matter. I rose and I said, I stood and I said about what are the service standards that we're going to have? Why are they not in this legislation? And I was admonished at the time to say that has no place in the legislation. Those will come later. We asked to see them. We asked to see a regular report as to how we are doing. To my knowledge, I have not seen them. I have not seen a regular report saying, how are we doing? How long does it take us to process a change of director? How long does it take us to process some of these matters? I am told by the service providers that we are talking weeks, months, years in cases, and I am deeply concerned about that. Not about the bill that's in front of me, sir. I support the bill completely. I'm concerned about our ability to implement it. Let me give you another example, sir. As the senator, the Honourable Senator, the Honourable Senator, Leader of Government Business, Lisa Cummins, told us all companies with revenue under $1 million are going to be required to file in person because they will not normally go through a service provider, and the unit is going to assist people in doing that. That is great news. Thank you. All companies must register within 3 months. That's 90 days. It's actually, if we look how many working days that is in 3 months, I will call it 5 working days a week. Over the 12 weeks gives us 60 working days. My math is correct. You're an accountant like me, sir. 60 days. My understanding is there are 20,000 companies under $1 million. This means that this unit needs to be prepared to register a minimum of 300 companies per working day in order for this to be on site.
Mr. President, I raise on a point of order. I know genuinely that the Honourable Senator is not misleading the House on purpose, but just to suffice to say that since January of this year, even when I was still minister and before this legislation started, we began the process of working with those companies in dedicated sessions to be able to begin the process of onboarding them, so that by the time the legislation was debated and hopefully passed, we would be in a position to onboard them. So that process has been ongoing. This is now 6 months in for the year, and that work has begun, and I believe it is continuing under my successor.
Please continue, Senator Honourable.
Thank you, sir. And I thank the Minister for the intervention, and I'm glad to hear that. And I look forward anxiously to the report that will be forthcoming telling us that we actually made the deadline and we were able to do this. So I raise it as a concern. I'm very glad that it has been looked at in advance. So, sir, when I talk about implementation, I don't talk about this lightly, because often in here you've heard me talk about the legislation that we have passed, and we often will tap on the table and clap to ourselves when we pass legislation. I don't do that. I look for when we actually implement it and do what we say we're going to do. And I have been told many times in here that we're the legislature. We are not the ones who have to enforce it. But we can't ignore the fact that many of the things that we are passing in here are not being enforced. And I'm sure I don't need to list them all for you. I have my own pet peeves with people driving in the back of open back trucks, and we have laws for that, and not wearing helmets, and maybe even the one that we spent so much time talking about, the noise pollution and kites. I didn't notice any difference because how do we implement it? How do we deal with it? So let me turn my attention to the last thing, which I regret to have to do, but I shall do, as I think it is my responsibility as an independent senator to do so. When we speak of implementation, and we look at what this particular piece of legislation is, which I support completely, I want to line it up vis-à-vis the Integrity in Public Life Bill 2023. For those who may not remember, that piece of legislation was introduced. Notice was given on the 27th of January, 2023. I will bore you with all the stages, but just to say that I was in this chamber on the 16th of August of 2023 when that legislation was passed. To date, almost 3 years later, it has not been proclaimed. Again, for those who may be hearing my voice and not as familiar with this as others, and I had to learn as I went along, the stages that these bits of legislation go through that we all are involved with, after the bill is introduced in the lower house and it is passed, and it comes to the upper house and it is passed, the bill is presented to the President. Now, there has been no information that I have had to say that this bill has been refused by the President or accepted. The President may withhold assent, but we would know about that. So all I can conclude at this point in time is that that piece of legislation has not been presented because it has not been assented to. And that gravely concerns me because, frankly speaking, that piece of legislation plus this piece of legislation should work hand in hand. In fact, if you compare the two pieces of legislation, the Beneficial Ownership, Transparency and Register Bill places the responsibility on companies, societies, partnerships, external companies, beneficial owners, nominees, service providers, to do with the private sector. In similar fashion, the people included under the Integrity in Public Life Act are the parliamentarians, the ministers, senior public officers, senior state enterprise officials, and other specified persons. The objectives are not dissimilar again. The information disclosed, for example, under the Beneficial Ownership and Transparency Register Bill, which I support, I see it in all the sophisticated jurisdictions that I may do business with, the identity and the method of ultimate ownership or control. That's what we're getting to. Under the Integrity in Public Life, which we all clapped our hands on the table to and rejoiced in passing, asked for the full financial affairs, family assets and liabilities, business interests, gifts, and any conflicts of interest for the persons covered under that Integrity in Public Life Act. I won't go through to talk about all the other similarities between the two, but they both together have the same goal, and they should work together. And it is precisely why bringing only one system into force is going to be incomplete. The Beneficial Ownership Register tells the state who is behind the company. The Integrity Declaration tells the state what the official owns and whether that ownership conflicts with the public duties. These two pieces of legislation, both of them excellent, need to be proclaimed and enacted jointly. There is no reason that I can understand as to why we would be spent the last 6 months apparently getting ready, being prepared. We are ready. We're going to implement this on the private sector. From the time it is passed, let's get the clock running. But nearly 3 years has passed, and we've done nothing about the Integrity in Public Life legislation. It's not even been presented, from what I can see, to the President. I don't know. Perhaps it has been. So, for me, I'm sorry it's late in the hour, and I'm sorry that I have to stand and say this, but I find it very difficult that the same government who is asking for the transparency that is essential for the companies, essential for the private sector, they have not implemented the bill that we passed in here that was thought out. It was part of a manifesto, I believe, of the government, and it has not been proclaimed. And I do not know why, and I would ask why. And I'm calling for the simultaneous proclamation of both of these acts. I'm fully in favor of this act. I would like it proclaimed as soon as possible, but I want it to be proclaimed at the same time that the other one is, so that the two of them can work hand in hand. So, Mr. President, I hope I have been clear. I support this act. I'm concerned about the implementation. I hope we have the resources. I'm assured by the good senator that they have been prepared and getting ready for it. There are concerns about the cybersecurity, but those are concerns all around, and paper doesn't solve the problem. And the truth is, if you're a target, this is going to be the least of your problems, to be quite honest. So I have those concerns. I'm concerned about the implementation. I hope we're not just window dressing and passing a law that we, in fact, cannot implement properly. But I do call for the government to speak to us clearly on how we will simultaneously enact the integrity in public life along with this one. With those words, sir, I'm obliged to you.
Thank you very much, Senator Malado. If there are no more speakers, I'll ask Senator Cummins to wrap up.
Thank you very much, Mr. President. I want to thank the honourable senators who have spoken. I want to begin by attempting as best I can to Senator Goodridge's contribution. So as it relates to cybersecurity, the Minister of Technology sits in this chamber, and I believe that just like Senator Malalou, he will tell you cybersecurity exists, cybersecurity concerns exist in the public sector and the private sector. And the government of Barbados, and I believe it has been announced publicly, under the leadership of the Barbados Defense Force, that has now been the agency, and I believe that Senator Goodridge, having raised questions, should be interested in the answers so that she would make sense in her submissions a little later on, as she has quite rightly said before. So the answers are important. So we want to make sure that the role of the Barbados Defense Force, which is responsible for, by definition, security, they have been beefed up, and there is a dedicated cybersecurity unit that has been staffed in the Barbados Defense Force. They lead on behalf of the government. They have brought in and bought in all of the private services that are necessary, but across the government as well, under the leadership of the same unit in the Barbados Defense Force, we have a number of persons on retainer in various agencies, including in Business Barbados, because we had to identify persons who are in overseas markets, and in some instances, you hire ethical hackers to be able to make sure that you have all of the protections in your system under the leadership and the supervision of the team of the Barbados Defense Force. That has been in place. If people want to be able to come to you, they will come to you. And then there are people who think that they are super smart and they think that they're always going to outsmart everybody. And when a link comes to them and it tells them, click here if you want more information, boom, you, by your individual action, have invited malware into your system, and you have suddenly been exposed and potentially exposed everybody on the network to which your device is connected by a single action. So there is, in this as well, individual responsibility, but the firewall systems and the cybersecurity systems are always being upgraded for the benefit of the government agencies. Now, excuse me, I want also to respond to the queries that have been raised by Senator Malalou. Let me start first by going through the queries relating to the operation of the implementation of the entity. Yes, since earlier in the year, the team began the process of training in the first instance and then sensitization of the business community. And that came out of a November 2025 study tour. It was to the Cayman Islands, where they looked at the legislation in Cayman. I know that the Honourable Senator is very familiar with the operations of different jurisdictions across the region, and they went physically there, met with the officials there. We had a consultant from last year on staff looking at what was being done in other competing jurisdictions, and out of that, a best practice model was built along with the overall guidance of the FATF. And so there were a number of summary recommendations prepared in a November 2025 report on the beneficial ownership regime specific for Barbados, including, but not limited to, technology. And so those recommendations have been embedded since November, training started since January, sensitization started since January, so that you're not now beginning to go through all of the companies that are eligible, but you would have started the process. I want also to say that I don't know from 1997, when I joined in October of 1997, when I joined the Ministry of Foreign Affairs and Foreign Trade as a Foreign Service officer, to any of the encounters that I have had for 10 years as a Foreign Service officer, or how many ever years since then as a public officer, I have never in any legislation seen treaties and treaty obligations listed in domestic legislation unless it is about the ratification of said piece of legislation. I've never seen it. And so if we have, and I mentioned them before in my initial presentation, I talked about the Mutual Legal Assistance Treaty, for whom the competent authority is the Barbados Revenue Authority. We have sat in this country, I believe, I remember, Mr. President, there are only a handful of us who were in the Senate in 2018. Only a handful of us who were in the Senate in 2018. In this chamber, even before COVID, when we had a landmark night, I believe Senator Rogers was one of those handful of persons. We left in here after midnight, December, just before Christmas. The clerks would recall it. We had a landmark night in this chamber because we had to pass about 13 pieces of legislation overnight. And it was because one of the things that we were always clear of, whether it was in 2018 or in the years prior, or in the years when there were previous ministers with responsibility for international business, the goalposts are always moving. Under what circumstance where you know a goalpost is always moving and the requirements are always changing, would a government, a responsible government, embed changing regulations and changing regimes in fixed, static legislation? That's not what's done. There's no precedent for it. It's just not done. And so, Mr. President, if I decide that I'm going to buy a new car next week, and the licensing authority decides I'm going to keep my registration number, or I'm going to get a new registration number, am I going to put my old registration number in a static document? Absolutely not. Things that can change do not go into legislation. Things that are specific to international obligations that evolve do not go into legislation. And I'm surprised to even hear that at this level in this honorable chamber, to be honest, Mr. President. But I wanted to clarify it nonetheless, because we would not ever see that happen in the text. And then finally, I want to actually agree, and I know that Senator Malalou may be surprised when I say this, but when we were doing the Electricity Supply Act, for example, one of the innovations that we required as a team was that if you are imposing obligations on business or on the sector, you also have to give some predictability in how quickly things can be turned around by the government. And so we set timelines too. So the statement that there should be an equivalent timeline to the 14-day deadline for businesses, that there should be clarity, whether it is 14 or some other number, there should equally be clarity about how long we expect the state to turn things around. I don't step away from the fact that, and I've said this to teams, especially when I was in the Ministry of Business, the length of time that something stays on your desk and is unturned around is a cost to business. And then we have all kinds of run-on effects. And I absolutely agree that there should be timelines within which we set standard operating procedures. But that is not to say that in an entity like Business Barbados that they do not exist. I happen to know, because they don't report to the legislature, they report to the ministry under which they sit. So they would have already introduced a series of standard operating procedures. They're transitioning still, as we know. Hopefully, I expect that they will be in a position to have and onboard a brand new register in the shortest possible time frame. I expected it should have been completed by now, but that is underway. But their reporting mechanism is not to the legislature. The only entity in law that reports to the legislature is the Public Accounts Committee, which sits under Parliament. Every other entity would report into their line ministry. And so you may not have seen the report, but the reports have very much been in existence. So I want to say that this is important legislation, and I'm grateful for the support that colleagues have raised. And I beg to move, Mr. President, that this bill is read a second time.
The question is that this bill be read a second time. Will those honourable senators in favour please say aye?
Aye.
Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move the Senate resolve itself into committee for further consideration of this bill.
The question is that I do not leave the chair, and the Honourable the Senate resolve itself in the committee for further consideration of this bill. Will those honourable senators in favour please say aye? Those against please say no. Methinks the ayes have it.
The Honourable the Senate is now in committee.
Part 1, clauses 1 through 5.
Madam Chair, I beg to move that Part 1, clauses 1 through 5 do now stand part.
The question is that Part 1, clauses 1 through 5 do now stand apart. Will all honourable senators in favour please say aye? Aye. Those against, would you please say nay? The ayes have it.
Part 2, clauses 6 through 12.
Madam Chair, I beg to move that Part 2, clauses 6 through 12 do now stand part.
The question is that Part 2, clauses 6 through 12 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say nay? The ayes have it.
Through 18.
Madam Chair, I beg to move that Part 3, clauses 13 through 18 do now stand part.
The question is that Part 3, clauses 13 through 18 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say nay? The ayes have it.
Part 4, clauses 19 to 22.
Madam Chair, I beg to move that Part 4, clauses 19 through 22 do now stand part.
The question is that Part 4, clauses 19 through 22 do now stand part. Will all honourable senators in favour please say yes? Yes. And those against please say no? The yeses have it.
Part 5, clauses 23 to 25.
Madam Chair, I beg to move that Part 5, clauses 23 to 25 stand part.
The question is that Part 5, clauses 23 to 25 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say nay? The ayes have it.
Part 6, clauses 26 to 28.
Madam Chair, I beg to move that Part 6, clauses 26 to 28 stand part.
The question is that Part 6, clauses 26 through 28 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say nay? The ayes have it.
Part 7, clauses 29 to 39.
Madam Chair, I beg to move that Part 7, clauses 29 through 39 do now stand part.
The question is that Part 7, clauses 29 through 39 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
The schedule.
Madam Chair, I beg to move that the schedule be the schedule to the bill.
The question is that the schedule be now the schedule to the bill. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Report.
Madam Chair, I beg to move that you do now report to His Honour the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Will all honourable senators in favour please say aye? Those against, would you please say nay? The ayes have it.
Her Honour, the Deputy President has reported to me the pass of one bill in committee. Senator Cummins.
Mr. President, I beg to move that this bill be read a third time.
The question is that this bill be read a third time. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do not pass and be cited as the Beneficial Ownership, Transparency and Register Act 2026.
Order. Order, honourable senators. The question is that this bill do not pass and be cited as the Beneficial Ownership, Transparency and Register Act 2026. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. This bill is now passed and so cited. Senator Cummins.
Mr. President, thank you very much. This is an important piece of legislation to have passed, but it does bring us to the end of government's business for today. And with that said, I beg to move that the sitting of the Senate be adjourned sine die.
Honourable Senators, let me thank you very much for a full and engaging day. It was a great interest to follow your contributions on these two substantive matters, and I thank you for your active engagement. The question is that the Honourable the Senate be now adjourned sine die. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Senate stands adjourned sine die.